The Committee on Criminal Jurisprudence will come to order, and the clerk will call the roll.
Chair Smithy,
Here.
Vice Chair Wu, Representative Bowers, Representative Cook, Representative Jones, Representative Little, Representative Louderback, Representative Money, Representative Moody, Representative Rodriguez Ramos, and Representative Verdell.
So a quorum's present. We'll go ahead and come to order. Members, this hearing obviously was posted, and with pursuant to the announcement on the House floor, we're convening a little bit past 30 minutes after adjournment. So it's the chair's intent to go ahead and vote on the list of bills that we sent out to you all. And but I like to get a couple more members here first, so we might go ahead and take up a bill. Let me just make just a general announcement, and that is that if you intend to testify, make sure you filled out the electronic witness affirmation before you get up, because we can't, to protect these bills, we can't let you testify until you've actually filled that out. If you wish to register your support or opposition to a bill, you can do that on the form without testifying, and the committee will be apprised that you're for or against a bill. We also impose a 3-minute time limit to try to get all the witnesses on at as reasonable of an hour as possible. We have a fairly large agenda today with a large number of witnesses, so we would ask that you hold your testimony to 3 minutes. There's a timer up here, and I don't mean to be rude, but I may interrupt you and say thank you, and then the committee will have a chance to ask you some questions. And we'd ask that everybody please stay on topic of the bill, and members would address your questions on topic to the bill that's in front of the committee. If you would, we would appreciate that. So Ms. Howard is here, and so we'll go ahead and call you, and we'll at least get your bill knocked out before we, no pun intended there, but we'll get your bill done, hopefully, before we vote. And then as soon as we do as soon as we get some members here, we'll vote on some things. But the chair would, at this time, lay out House Bill 47 and recognize Representative Howard.
Thank you, Chairman Smithy and members, for the opportunity to lay out House Bill 47. I'm going to give you a quote now. As Texans, we embrace the right of all citizens to live safely and securely. With these goals in mind, committed professionals and volunteers across Texas remain dedicated to invaluable work in crime prevention, law enforcement, prosecution, advocacy, and victim support, helping to create a better, safer future for all Texans, end quote. This was Governor Abbott's opening statement from the 2024 Sexual Assault Survivors Task Force report to the legislature, and perfectly encapsulates the SASTF, Sexual Assault Survivors Task Force, and their work. The task force was created in 2019 to establish a survivor-centered, collaborative, and coordinated response to sexual violence in Texas. Over the last 2 sessions, they have sent dozens of recommendations to the legislature, and we have consistently shown bipartisan support for their work. The dedicated stakeholders, experts, and survivors who comprise the SASTF have transformed Texas's response to sexual violence in the areas of safety and public awareness. Now, this session, they seek to build upon past efforts through 10 recommendations, 9 of which are included in HB 47. Specifically, the SASTF Omnibus Bill seeks to enhance safety measures for Texans in their homes, when using public transportation, in the court system, and in the healthcare system. This bill is large, so I'm going to just real quickly walk you through the main provisions of the bill. First, we'll talk about how HB 47 addresses safety in the home. Following their assault, some survivors may need to move out of their home. However, if a victim needs to terminate their lease, current law requires the sexual assault to have occurred on the property. However, we know that the majority of rape victims are assaulted by someone who is known to the victim, which often means that the perpetrator knows where the victim lives, and some perpetrators use this knowledge to further torment and harass their victims. Every survivor has the right to feel safe in their homes, even when their assault occurs elsewhere, which is why HB 47 would extend victims' rights to terminate their lease irrespective of where the assault occurred, provided that the victim presented the landlord with the appropriate documentation as provided by Section 92 of the Property Code. Second, let's talk about ensuring the public safety when using public transportation. Currently, a dangerous loophole exists in our public transportation laws that leaves rideshare customers vulnerable to sexual offenders. Though federal law currently prohibits people who are on the federal sex offender registry from being hired as a rideshare driver, no such protection exists at the state level for people who are on the Texas sex offender registry. This bill would prohibit all registered sex offenders in Texas from being employed as rideshare drivers. Next, I'm going to mention how HB 47 improves survivor safety in the court system. We know that nearly 90% of all survivors do not report to law enforcement. Survivors who do actually bravely step up and choose to report their assault deserve to be supported and feel safe throughout the process. This bill would require courts to consider the impact on adult sexual assault survivors when a defendant seeks a continuance of their case. Current statute limits this right to child sexual assault survivors and family violence survivors. HB 47 would also require HHSC information sheets provided to survivors to include legal services information, offering easier access to services that could enhance their safety and understanding about the legal process. HB 47 also ensures survivors have ready access to the basic health care services they need in the hours, days, and weeks following an assault. This bill would require all emergency room medical personnel to take a trauma-informed training that will ensure survivors receive competent medical care during their exam. Further, the bill would allow survivors to be provided with HIV prophylaxis, STI care, prescriptions, and related follow-up care for a period of 30 days after their forensic medical exam, all to be reimbursed through the Crime Victims Compensation for Emergency Medical Care. HB 47 would also reduce barriers to sexual assault nurse examiner training by extending their certification from 2 years to 3 years. Finally, the SASTF Omnibus would promote greater public awareness of Texas's response to sexual violence by requiring that the data collected by the adult sexual assault response teams be submitted to the SASTF in the Office of the Governor on a biennial basis. So I will try to answer any questions you might have. I know that there are some members here that can elaborate more, but reserve the right to close.
First, I need to acknowledge that Vice Chair Wu and Speaker Moody have joined us. Anyone else that I missed that came in after roll call? Okay. And so, any questions for Ms. Howard? Okay.
Mr. Chair.
Mr. Little?
Thank you, Mr. Chairman. Thank you, Representative Howard.
Yes.
I spent a lot of time with your bill last night, and it does a lot. This is a very real problem that your bill is attempting to address. For example, my understanding is in the city of Houston, there's literally a backlog of thousands of cases of sexual violence that have failed to be investigated, failed to be prosecuted for either willfully or through a wanton act of neglect, certainly on the part of law enforcement officials or district attorneys in Harris County. I have some questions about the things that your bill does. There are many.
Okay.
So I'm on, there's a section dealing with non-compliance under the government code, says failure to comply with the requirements of section 351.257 may be used to determine eligibility for receiving grant funds from the Office of the Governor or another state agency. This is in section 16 of your bill.
Okay.
Can you just elucidate for me what that does?
My understanding is that this is just to provide some kind of an enforcement for submitting the SART report to the SASTF. Right now, a lot of them voluntarily do that, but not all do. And I think this is a mechanism to ensure that there is that transfer of information from the not only to the county commissioner's court, but also to the SASTF.
Okay. And I have a question about the next section of your bill. Well, it's sections 17 and 18, dealing with the training you were referring to earlier.
Okay.
Section 17 deals with continuing education and forensic evidence collection. And it requires training or medical education relating to, and this is again, in Section 17.
I'm trying to get there. Keep talking.
Yes, thank you.
Okay,
In Section A2, it requires training on appropriate community referrals and prophylactic medications. In the absence of a definition, I don't know what that means. What does it mean?
I'm hoping that you'll be able to ask these questions from the SASTF members here or the head of that organization, that entity that can maybe address that more appropriately than I can. But appropriate community referrals would mean referring to advocacy groups that are there to help survivors. And prophylactic medications would be like the prevention of HIV, that sort of thing.
I can understand that level of prophylaxis from disease, but does it also encompass abortifacient drugs?
That's something we'll have to ask and see here. I'm not sure.
What do
I
you
can't
think?
answer that. I think there's a separate bill that's attempting to address that. So what is specifically mentioned, let me go back to what the SASTF report says. The most basic need for sexual assault survivors is ready access to health care in the hours after an assault. This bill would allow survivors to be provided with HIV prophylaxis, STI care, prescriptions, and related follow-up care for a period of 30 days after their forensic medical exam.
And the word prescriptions there is a broad one. And so one of the concerns that I have is this bill might be designed to be a vehicle for the prescription of abortifacient drugs at some point after an assault. And I don't want to launch into that whole discussion because I'm sure we'll have sincere disagreements about it. I'm just wondering whether you think that this covers that.
The intention here would, if it's going to cover anything, would be for the morning after.
HIV prophylaxis or for
If there was going to be a contraceptive type thing, it would be given at the time, not by an abortifacient, but by a Plan B, which is not an abortifacient.
And one of my concerns is, as you know, Representative Howard, there are oftentimes very real reasons that there's delayed reporting from a sexual
yes,
assault.
absolutely.
And I think you'll agree on that. And so are we envisioning the use of or prescription of an abortifacient drug for someone who is a delayed reporter and is 2 weeks, 3 weeks, 4 weeks, 2
Right.
months down the road?
Well, as you say, we can have some disagreements on what we think it should say and what it should be used for. And personally, I would, of course, think that it should be something that would be available.
Yes,
right now, we'll be following the law and what the law says about what can and cannot be given. That's my answer to you now.
I appreciate your answer. Thank you.
Sure.
Any other questions, members? Okay. Thank you, Ms. Howard. Will anyone you wish to call as the first witness, or?
Me?
Yes.
Oh.
I mean, anyone you think should be the first witness, or just call the list?
No, I don't have a suggestion. They're all excellent.
Well, nobody's.
I'll reserve the right to close.
We don't have anyone against the bill. We have several for the bill. Yvette Salazar. Okay. Samantha McCoy.
I meant to just register and support. I apologize. No testimony.
Okay, so, okay, you've got to come up and say that on the record if you don't mind. I'm sorry to do that to you, but if, yeah. So,
I meant to register and support. I apologize. No testimony.
state your name,
Samantha McCoy.
and you're not testifying, but you're in support of the bill?
Correct.
Okay, thank you very
Thank
much.
you.
And, do we have permission, come back up here, okay. Do we have permission to change your affirmation to non-testifying?
Absolutely.
Okay,
Yes.
thank you. We have Nicole Weaver. And for all the witnesses, let me just reiterate that we need you to say your name. If you're here on behalf of someone, tell us who you're here on behalf of, and yourself, if you're here for yourself as well, and then your position on the bill, if you'll clearly state that.
Thank you so much for your time today. My name is Nicole Weaver. I'm here representing myself, not an employer or another agency, and I am in support of the bill today. While every component of House Bill 47 is essential to enact, Section 20 relating to early lease terminations speaks to me directly. In November of 2011, I was working as a therapist in my home state. I was serving a client who was trying to leave an abusive relationship with a gang member. She had warned me that anyone who tried to help her in the past had been hurt by this person and the gang. We worked together to plan her escape, and I took any precautions I could to feel safe during that time as well. That sense of safety came crashing down when I arrived home from work one evening to find my client's partner and 5 additional gang members had broken into my secure building and were waiting for me in my apartment. I was brutally and violently assaulted for hours. During that time, the perpetrators consistently threatened me, letting me know they would always be watching me. They let me know how easy it was to find me. I was convinced they would kill me, but instead they left. Part of me did die that night. The confident and outgoing person I was before no longer existed. Other building members had witnessed these monsters going in and out of my apartment and advocated for me when I asked to break my lease. The landlord felt that offering me an apartment in another building 1 block away was a sufficient safety measure. As you can imagine, my perpetrator's threats of watching me rang in my head constantly. I couldn't feel safe 1 block away. In fact, I couldn't feel safe at all. This experience led me to relocate to Texas in 2012. I couldn't even comprehend moving 1 block from my current residence, which is why I couldn't even truly feel safe 1,800 miles away after the incident. Though the move was drastic and should have allowed me a fresh start and space for healing, it didn't. My previous landlord filed a broken lease because I declined her offer to move to a neighboring building back home. As I was trying desperately to recover from the assault, I was also having to recover financially. The broken lease stayed on my credit for years. As I'm sure you're aware, it's very difficult to rent a safe place with a broken lease on your credit report. No amount of explaining to prospective landlords what happened helped me in any way. I ended up in a second chance apartment in an unsafe neighborhood where I still had to pay a triple deposit. I couldn't recover there. I was terrified all the time, but I had no choice. I felt that so much had been taken from me that night, but I had no idea that I would also be facing financial and credit consequences for years because of my perpetrators. I can't even tell you how hard I worked during the 7 years that broken lease was on my credit report. At times, working multiple jobs to try to show creditors and landlords that I am a responsible community member and what happened was beyond my control. I shouldn't have had to do that. I should have been allowed to focus on my physical and emotional healing. I know I am not the only person who's experienced this, and I wouldn't wish it on anyone. While my situation is slightly different than to what the lease term... Sure. I just ask that this bill be passed so that other survivors don't have to go through this. Everyone deserves to feel safe in their home.
I think we understand. Thank you. Any questions, members? Thanks for, Ms. Little.
Ms. Weaver, I wanted to make sure I understood. In your story, were you assaulted in the same complex where you lived?
I was, but I was offered an apartment in a neighboring complex about a block away, and that's why the landlord felt they could put the broken lease on my record.
Okay, one of the reason I ask is my understanding of the law is it's already legal for you to break your lease if you're assaulted on the premises or where you live in that apartment complex. My understanding of what's been proposed in this bill is that it would allow you to break your lease if you were assaulted even somewhere else. Is that your understanding too?
It is. I just wanted to show the financial consequences that impacted my life for an extended period of time due to a broken lease, even though the assault did occur in my home.
That makes sense. Thank you, Ms. Weaver.
Yes, thank you.
Okay, thank you for
Thank
being
you.
here. The record needs to reflect that Ms. Rodriguez-Ramos is present. And so we almost have a full house where we can vote, but we'll go ahead and finish with the witnesses on this. We have, Jamie or Jaime?
Jamie, sir.
Okay, I'm sorry, Jamie Felicia, the chair calls.
Good afternoon. My name is Jamie Felicia, and I am for House Bill 47, and I am here today as a representative for myself. I have been a Texas lawyer since 2007 and am board certified in criminal law. I've been a prosecutor since 2008, and I'm honored to have this opportunity to speak in front of you today. When victims of adult sexual assault hear that a case has finally been set for a jury trial, many things go through their mind, including, I will finally have my chance to be heard. As prosecutors, we try to prepare victims for the likelihood that a case will not be reached in its first trial setting, usually because older cases are set on the same date. However, after multiple jury trial settings have come and gone, that conversation gets much more difficult. Every time the case starts approaching the new trial date, the fear, anxiety, and pressure come with it. My good friend Marcus Reese put it this way: as a victim and survivor, it's difficult to express the feelings of powerlessness that happen when your trial dates get reset over and over. It feels as though the system minimizes the effect resets have on the victim and their well-being. Personally, the more resets I encountered, the less motivated I was to continue to participate in the judicial system. Each court date, I remember mentally preparing to face my abuser and to start the process of trial, just to be told that another reset had happened. As Marcus noted, their case lingering in a system that isn't built for them causes survivors to consider whether or not it's worth continuing forward with the case. As a prosecutor, I'm sure our words feel empty as we assure survivors that justice is a cause worth waiting for. So why this legislation and why now? A quick look at the DPS 2023 crime report may give some insight. Since 2020, the number of sexual assault cases cleared continues to drop. In 2020, the rate was 20.5%, and since then, we've fallen all the way to 14.7% in 2023. What does this drop mean? It means that survivors are waiting longer and longer for justice and closure. However, you can change that. One small step. One small change to this existing statute will give adult sexual assault victims a voice in a courtroom in a new way. Please take this one small step to give a big improvement for all adult sexual assault survivors waiting for their opportunity to be heard.
Thank you, Ms. Felicia. Any questions? Mr. Wood has a question.
Thank you so much for being here. And you've been a prosecutor for a while, I assume.
Yes, sir.
And you've handled many domestic violence, sexual assault protective orders and things like that.
Yes.
Correct. I know one of the provisions of HB 47, especially dealing with protective orders, I think is really important. Could you explain some of the issues of, like, under the current law, what the problems are in helping get protective orders for victims and things like that?
Absolutely, and I want to answer your question as best as I can. Can you point me to the part in the legislation that you're talking about?
Apologize, I don't have it tapped out.
No, that's okay.
But I know that it lowers the barrier. The bill seeks to lower the barriers for survivors seeking protective orders, and we can go discuss it later if it's not.
Sure.
I didn't mean to drop that on you.
No,
also.
that's okay, and I would love to be able to answer your question more specifically. I will say that protective orders give a sense of security to folks who have just been through the worst thing imaginable, and anything we can do in order to help give them that support, I absolutely think we should do.
Thank you.
Thank you. Any other questions? Oh, Ms. Jones has a question.
Yes. Nice to see you.
I was getting ready to say, I know Jamie.
It's been a while.
I mean, prosecuted people that needed to be prosecuted and made decisions based on fairness.
Thank you.
So, what is it in particular about this bill that you like and why you want us to vote for it?
Absolutely. So really my time I spent discussing the very first section. I spent a lot of my career handling child sexual abuse cases. And when I moved offices in 2018, I started handling adult sexual assault cases as well. And I thought I had this wonderful tool in CCP 2914 that would force a judge to say on the record in an open courtroom why they were continuing a victim's case. And I did, as long as my victim was a child. But as soon as that victim turned 17 years of age, that tool was gone. And how do I explain to, I don't know if y'all have teenagers, but I do, and how do you explain to a teenager that because they turned 17 one day, they no longer have the same rights and laws afforded to them that a child who's 16 years and 360 days has afforded to them?
And I will say, as a practicing lawyer, that it is very difficult. I know that when I'm preparing my clients, they're anxious.
Sure.
They've got to go back and relive everything.
Their
And
families.
and so then once they get through the anxiousness and we sit down and we talk about stuff and they are trying to hold themselves together as I'm preparing them for trial.
Sure.
Right? It's especially because there's a, and it's not in my capacity as a criminal defense lawyer, it's in my capacity as people who've been a victim of a crime, and sometimes they don't think the prosecutor's office is adequately representing their rights, and they want for me to strongly encourage the DA to push forward. And then there's continuances. And it's like they're being re-traumatized every single solitary time.
Absolutely.
And so I don't think I realized that you lost that when you were an adult. I'm so used to, and a lot of times the defense wants to kick the ball down the court because they're thinking they're going to wear you out.
Exactly.
They think they're going to wear you out. You're going to give up. You're not going to come back to court. Maybe they know you have a job, and so you can't miss work another time because you've got to actually be at court, whether you go to trial or not. So I think it would be good to know specifically why your case is being continued. I also believe that will cause judges probably to be less likely when they've got to put something in writing for why they're doing something. So thank you for coming. I actually didn't even know that you came and testified on stuff. So it's nice to see you again.
Nice to see you. Thank you.
We do appreciate you being here. Is that all, members? Thank you very much.
Thank you.
We have next Nicole Martinez. Thank you for being here.
Thank you, Chairman Smithy, Vice Chair Wu, and esteemed members of this committee. My name is Nicole Martinez, and I am the administrator for the Governor's Sexual Assault Survivors Task Force. I am here today to be a resource witness and to answer any questions you may have about House Bill 47, which is the task force's omnibus bill.
Well, we know the task force has put a lot of time into this, and we appreciate that effort. Any questions, members? Mr. Little has a question.
Ms. Martinez, thank you for coming to testify. Did you have a chance to hear my questions about the abortifacient aspect of it? Do you have an interpretation of that?
Yes, and the answer is no.
Okay. What do you understand the community referrals and prophylactic medications to be?
We do have a sexual assault nurse examiner who is a forensic nurse available to answer some of those detailed questions about the said medications. However, specifically knowing that it's HIV prophylactics, could possibly be other medications necessary dependent on what type of assault occurred and what injuries the survivor endured.
I can understand that, certainly. The other question that I was wrestling with as I was reading the bill is why we need an expansion of the lease violation or the lease cancellation provision from on or in your own dwelling or in your own apartment complex to call it a more remote use of that cancellation. What do you think about that?
So the legislature mandated the task force to develop statewide best practices of response and care for survivors. In our biennial report, we articulated our whole survivor care guiding principles, one of which is safety. So this provision of the bill addresses safety for the survivor. We do recognize that most sexual assault offenders know the survivor and may know where they live. And so this adds additional protection to that survivor because of fear of their safety.
Sure, and I'm trying to decide what I think about it, and I'm not quite sure. And so the idea is that you're trying to make the victim more safe by allowing them to move somewhere else, right? And break a lease if necessary. Yeah, okay. Thank you for answering my question.
Mr. Moody has a question.
No, and comment just overarching everything. I appreciate the work that you've done in prior sessions. Come forward with other fantastic recommendations that I think legislature has enacted almost in if not in their entirety, I think almost in their entirety. On the point of the leases, and I do think you kind of drilled into, or you touched on it a little bit, majority of these crimes are not stranger crimes, correct? So you're talking about people that do have, for the most part, there is some relation when these offenses take place. There's some knowledge of the victim, where they are, what they're up to, and so this provision is really going at the core of the fact that these are not stranger crimes, and if we're going to center safety for the victim, where that offense took place is really an arbitrary barrier to their safety, and that's the way that I read this portion. Is that kind of what bore out in your all's research?
That is correct. Yes,
Okay.
sir.
All
Thank
right.
you.
Thank you very much.
Thank you, and I need to clarify on the record that you're signed up neutral on the bill because of your position.
Yes, sir.
Okay, any other questions, members? Thank you for being here once again.
Thank you very much.
Next, the chair calls Beth Maker. Thank you for being.
Thank you. Good afternoon. My name is Beth Maker, and I'm here on behalf of myself and for House Bill 47. I want to thank you for allowing me a few minutes to visit with you about the follow-up care that is addressed in House Bill 47. I am a sexual assault nurse examiner, SANE for short. I have been a sexual assault examiner for 12 years, and I have worked in various parts of the state of Texas, Lubbock, Amarillo, Round Rock, and now I'm currently in the DFW area. In my career, I've taken care of approximately 1,200 patients. I would like to, first of all, talk to you a little bit about what happens to the patient when they come into the hospital for their exam. Typically, they're coming into an ER. They're coming in through triage. If any of you have ever experienced the emergency room, you know nothing happens fast there unless your heart's not beating, you're not breathing, or there's blood everywhere. Then things might pick up just a little bit. So the patient presents into the ER with a complaint of sexual assault or a concern for sexual assault. They then are taken into triage, then they are put into a hospital ER room. They then are assessed by either a medical physician or a physician's assistant or a nurse practitioner. All of that takes time, and they're assessed in any additional medical interventions that needs to be taken care of before I come on board. This is an additional 1 to 2 hours that they have been in the emergency room. Then I come in, and that the exam itself can last anywhere from 2, 4, 5, 6, or longer hours, depending on what we have to do. Many times the patient then has been up all night or has been up several hours with little or minimal sleep. They have had little to eat, maybe little to drink. They oftentimes have not bathed, showered, nor changed their clothes. So after this extended length of time after the exam, then I need to sit down and talk to them about some very important steps that they need to take next. Prophylactic medication, follow-up care, follow-up STI testing. And so as a SANE nurse, I look at them, there's a glazed look over their eyes. They are done. Their brain is on overload. They cannot comprehend, they cannot absorb any more information. So without having to be able to bring them in for follow-up care, I have to hope and pray that they heard some of what I had to say and are able then to take care and do the things that we suggest. So for a follow-up visit would allow me to, one, physically assess any injuries that were existing at the time of the exam or any signs and symptoms of current injury. As far as from a public health, it would allow me to assess, have they followed up with STI testing? Did the medications work? That type of thing. Then also, from an emotional, psychosocial perspective, are they eating? Are they sleeping? Have they returned to work? Have they returned to school? Can they take care of their life? Can they take care of their children? Or have they returned to their home, locked the doors, closed the curtains, and withdrawn from life? So all of those components make up why it would be important to be able to bring those patients back in to visit with them.
Thank you. Are any questions, members? Let me ask you one question. I mean, what you've described is a very difficult experience after a trauma.
It is.
And so have you ever seen an indication that if the similar thing happens again, that they may just not even come?
You are exactly right. And unfortunately, we do have patients who it has happened to them multiple times and they do come in. But a lot of times they don't. They're like, it's just, I
It's not
can't do
worth the
that again.
trouble.
I cannot
Yeah.
do that again.
Okay. Any other questions? Thank you so much for being here. We appreciate it. Oh, okay, Ms. Jones has a question.
So there's a 120-hour, I guess, mark where you have to ask for this within 120 hours. Is it your experience that all sexual assault survivors are even prepared to come in within 120 hours?
No, ma'am. But keep in mind, the 120 hours pertains to evidence collection. We still can do an exam, whether it happened yesterday, last year, 10 years ago. We can still do parts of our exam, but the 120 hours is evidence collection. And yes, it is, to think that they process that. And
Because I know that I've had clients that they just were in shock, like it just took them a moment to move, and process, especially if it was someone that they knew.
correct.
And they didn't expect it. And of course, I know a criminal defense lawyer's dream is for there to be no evidence of anything. So we want for the sexual assault survivors to go to the hospital so that they can have the forensic exam, so that they can get DNA and see if there's semen there or whatever, or fingerprints or DNA on their bodies. But and I mean, and the truth is, you get the evidence when you get it. And if like, I don't know, maybe something like undergarments or something, it might have something. But I was just wondering about that because I don't always see where they are prepared to even deal with what just happened to them that quickly.
You are exactly right. And when I'm asked a lot of times in testifying in court, why did they maybe wait to come in and wait to report? It's because they're still trying to wrap their brain around what happened. Did this really happen? Victims, patients have a lot of self-blame. Well, maybe it was my fault. Maybe I did something to bring this on. And so in our exam, too, is a lot more than just the collection of evidence. The history we get, and I won't get into all of that, is evidence in itself. And so, yes, do we sometimes get DNA, and that's what attorneys want? Yes, but it's more than that. I want to assure, as a healthcare provider, first and foremost, I am a nurse. I want to assure them that their body is physically well. If it's not, here's what we need to aid in that healing, and that what else then can we do to help them on their way to that healing?
And sometimes the perpetrator will like come to the hospital with them or show up. Sometimes the perpetrator will even like call them and try to explain away. Sometimes you have children with the perpetrator.
Yes, ma'am.
And people don't want to think about this, but when you're violated in the sexual parts of your body, to have a medical professional have to go to those very places where you really are in real life, you don't want anybody in those places. That's hard to process as well. So I just think that we need to figure out how to be as supportive of the specific needs of the survivors to make that experience as least difficult and traumatizing as possible. Even though you're trying to collect the evidence for a good reason. You want to hopefully have evidence to be able to prosecute the perpetrator. It's just a re-traumatization, I believe.
It can be. And we, as a state, have moved forward and have greatly improved how it was when I first started this
And
work
that's part
12
of what
years
this
ago.
bill's about, I know, so.
And
Thank
that
you.
follow-up care would do wonders for that healing, so.
Well, thank you very much for being here. Members, the chair calls Bertha Lavinia Masters. Dr. Masters?
Good morning. My name is Lavinia Masters, and I am representing myself. I'm Lavinia Masters, the namesake House Bill 8, the Lavinia Masters Act, and I am here to first recognize everyone that's here to hear us today and to support this omnibus bill that's presented to you guys today. And at first, if I can just say this, I want to apologize if we make this look easy as survivors of sexual violence. Being raped is not easy. It's never something that we want to continue to share and pour out of us. It's taxing. It takes a toll on us. And I know sometimes we may become callous towards it or numb because you hear it all the time. But I just want you to know that that's how we are as survivors. And I believe I speak for all survivors that are represented here today. And I just had to do that. And one of the things that a victim of sexual assault we love after being violated is safety. We want safety. And that's what this bill represents, safety in their houses. I was raped in my home at 13 violently by knife point. Health care, I was told, I over 8 hours of examination, and I was told I would never have kids. Thank God my mom was like, what kind of protection can you give her that she won't receive any kind of diseases or pregnancies, that what could I do at 13 years old? And so this type of bill I fully support, because we don't think about those things when someone is violated, when someone is violently raped. And that's what happened to me. And I like to use that word. I know we want to say sexual assault because it sounds nice. It's not a nice thing. It's not a beautiful thing. It's a heinous crime. It's devastating. It traumatizes us forever. We are not the same. Our healing is perpetual, and it's a continuance that we go through. And these laws are here to continue to protect other victims and survivors of sexual violence. I go through my healing phases, and I fight for other victims, and I pray that you guys are here to listen to us and to hear our plea for these changes in the laws that should not even have to be here in 2025. These are things that should have already been in effect, but we find the loopholes and we try to correct them. And I have more bills to testify on, so I'm going to leave you guys with that one. Thank you.
Thank you, Doctor. We appreciate you being here. And your your representative, Mr. Little, has a question.
Yeah. Dr. Masters, I'm
Yes.
sorry we haven't had the chance to meet before today. I just want to honor you for your testimony. Thank you for being here to share your story with us. We know that this is not easy. This is actually very difficult, in many ways re-traumatizing for people to
Yes,
come and
yes.
provide testimony. So I want to thank you for your courage in doing so.
Thank you.
We're certainly going to work to develop the best policy we can to help people who experience something so horrific.
I appreciate
Thank you,
that.
Dr. Masters.
Thank you.
Thank you very much, Doctor.
Thank you.
The chair calls Brenda Garrison.
Good afternoon, Chair Smithy and the committee. I appreciate the opportunity to be here and speak today. I'm the founder of Child Abuse and Forensic
Now,
Services.
tell us your name, first
Oh,
of all.
Brenda Garrison.
And you're here in favor of the bill, right?
I'm in favor of the bill.
Okay.
I'm sorry.
And then if you're here on behalf of yourself or in combination with an organization?
In combination with Child Abuse and Forensic
Okay.
Services. I've practiced as a sexual assault nurse examiner for the past 32 years. Opened the first private facility in the state in 1996 because I knew there was a need for a private and confidential facility to take care of these victims. I could talk on each one of these aspects of this bill, but what I want to concentrate on is the training requirement for our ER physicians and physician's assistants. Recently, we had a physician in a hospital that my organization is connected to. The sexual assault patient presented with a law enforcement request for a sexual assault examination. This doctor, quote, said, "There's nothing we can do, there's no evidence we can collect," so he did not request a forensic examination. This is a multi-county case and possible sex trafficking case. That patient now is refusing to come in. So we may have, we may never have that patient to come in and seek the care and the justice that they deserve. Lack of training leads to harmful mistakes. As a result, some of these victims get turned away. We have no way of knowing how many victims are turned away from the hospitals or the urgent cares just simply because the doctors are not aware of the law. Misinformation can cost survivors their justice and safety. When medical providers don't understand the law or trauma-informed care, the victims are the ones that pay the price. They may be turned away at their most vulnerable moment. They may lose trust in the system entirely. It can derail the criminal investigation, especially in trafficking cases where time is critical. The providers are often the first point of contact. ERs and urgent care centers are often where victims first seek help. If those providers aren't properly trained, victims may never be referred to a sexual assault examination. They may miss the window of evidence collection, counseling, and safety planning. Training's not just a best practice, it's a responsibility. Medical professionals should be equipped with the knowledge of Texas sexual assaults, trauma-informed care, and the proper protocol for minors. HB 47 ensures that providers receive standardized care training, improving consistency and accountability, and survivors are treated. This is a preventable problem with a legislative solution. Training doesn't just educate, it saves lives, preserves justice, and reinforces public trust in the system.
Okay. Thank you very much. Any questions, Ms. Jones?
Thank you for testifying, and thank you for being the first private facility in the state. Well, I was thinking, as a lawyer thinking about this, it's really important to get the survivors to medical professionals. Like what you said, you don't have faith and you won't come back because it was hard to get there in the first place. But I was even thinking about, like, evidence-wise, if you say something that's pretty proximate to when the event happened, it could be an excited utterance. Now, if you're not a lawyer, you don't know what that is, but it would come into a trial to be able to help prove that what happened at the time it happened. Whereas later, especially if your abuser is your intimate partner, right? Because some people think you cannot be raped by your intimate partner. You can, and you may be hesitant for whatever reason, and then we can use what you said because you haven't had time to, like, formulate lies or excuses to try to explain away. And when you've changed your mind later, and trust me, that happens all the time. I called the police on a number of occasions with my ex-husband, and by the time he finished calling me from jail and telling me he was sorry, and we have a child together, and don't do this to our child, and I love you, it'll never happen again, and I want everything to work out. And so I forgive him because I don't want to be a failure and have a broken relationship. And then I stopped participating. Like, I stopped talking to the prosecutors, and it's hard to make those cases. And the only reason that I didn't go through with it was for the cycle of abuse, and that's another story for another day. But if they do come in and talk to you, you can testify to what they said at the time.
Absolutely.
Right? And so I just think evidence-wise, if they don't come in, it makes it really much more difficult to prove a case beyond a reasonable doubt.
And especially if they've come in and you turn them away, the chances of us getting that patient back in is probably zero. And that 120 hours that we talk about all the time, that 120 hours is just a guideline. I've had patients that were nursing home patients. They were bedridden. So the evidence may stay in that body, in that cavity, much longer than a patient that's up and mobile walking around. Okay. So it's real important that these individuals, these doctors and physicians, they know the law and they understand it, because you may only get that one chance.
Well, thank you. Any other questions, members? Okay, thank you for being here. Tiffany Larson.
Good afternoon. My name is Tiffany Larson. I represent myself as well as the Brazos County District Attorney's Office, and I am testifying in support of House Bill 47. I have been a prosecutor for over 14 years now, and I've spent the last decade or so as a prosecutor specifically working on child sexual abuse and the sexual abuse of adults and family violence. I am the former chief of adult sex crimes in Harris County, where I practiced for many years, and I am the current chief of adult sex crimes and family violence in Brazos County at the District Attorney's Office. Good to see you, Representative Jones. I want to just follow up on a couple of things. I want to talk a little bit about the importance of the training aspect for our physicians in the emergency rooms and our physician assistants. We have to remember that the first point of contact at these hospitals won't necessarily be a SANE nurse. We have amazing SANE nurses here in the state of Texas, but the first person that they're going to encounter may not be a person with that background. This training is going to allow any person who's working in an emergency room to have the appropriate level of attention and care to a person who's been through this trauma and to all of our survivors of sexual assault. Whether you're in a big city at a smaller hospital or in one of our rural counties, it's important that the first person they encounter understands these things. I think it's already been touched on, but I do want to address your specific question, Representative Little. Because of that 120 hours, we do frequently see people in an acute fashion. And so to whatever degree within that 120 hours we would really have any concept of whether or not pregnancy has occurred yet, we just of course are looking at that prophylactic medical attention to whatever degree we possibly can. Non-acute reporting, delayed reporting is still a very big part of what we do. We want to get them whatever help they can. It's important to remember that this bill was put together in response to real issues that we've experienced here in Texas as prosecutors and as other practitioners. I'm the co-chair of the Prosecutor Subworking Group for the SASTIF, and this bill addresses the issues that we've been talking about for a few years now, and we really appreciate your support and attention to this important matter. I'll take any questions.
Any questions? But I do need to do, before you get away, we have on record 2 affirmations you signed, one and not testifying and the other testifying. Do I have your permission to delete the non-testifying
Yes, sir.
affirmation since you testified? Okay.
Yes, sir. Apologies. Yes, sir. Please.
That's all right. I just need to get that clarified on the record.
Thank you, sir.
Very much. Anyone else here to testify for, against, or on House Bill 47? If not, Chair recognizes Ms. Howard to close, and then we'll try to vote, members.
Thank you, Mr. Chairman. I'm not going to go through all the list of who's on the SASTIF, but I think it's important to recognize why this even came about in the first place, that we had law enforcement and healthcare and advocacy groups and DAs and DFPS, and the list goes on, meeting separately or in silos addressing these issues. This was an opportunity to bring all of them together and to come up with recommendations that they informed one another. I think that's been what's been so remarkable about this particular group. It is a well thought out package of recommendations, as you could hear from some of the folks that testified. If there's any other questions, I'm happy to try to answer them, but I would appreciate your favorable consideration. As I said, this has been ongoing, bipartisan, almost unanimous support every session with what they've come up with. I'd like to be able to keep doing that and keep improving the situation. So with that, I can close.
One question. Do you
Yes,
think,
sir.
do you anticipate a sub at any time, or do you think it's pretty much ready to?
I think so. Yeah, I think we're ready to go.
Okay. All
Yes,
right.
sir.
Okay. Any questions, members?
Real quick.
Mr. Little has a question.
Thank you, Thank you, Chairman Smithy. Thank you, Representative Howard, for your bill. This has been very helpful. The part that we didn't really get to talk about very much is the rideshare piece. Obviously, this is of great concern that we not have people who have this proclivity who are driving other people around. I got confused. I'm having trouble finding it. There are a couple of bills that have been, or at least a couple, that have been filed to address this, what I'll call the rideshare gap, with people who are potential violent sexual offenders being able to participate on the app. Does your bill require the rideshare companies to search any type of database?
Actually, that's a good question. I would have to look at how that process actually occurs. I assume that would be the case, but I don't know that I have the specific answer for you. I can certainly get you that answer. Let's see. They're already there's already a statute that requires, let me see if I can find it here.
So it's in section 7 of your bill.
Yeah, I'm trying to find that there. Thank you. So a person subject to registration under this chapter because of a reportable conviction or adjudication for which an affirmative finding is entered under Article 42.015B or another one. I don't see the specific words here that say how that is done, but my assumption would be, somebody's going to help me here. The state sex offender public website that's maintained by the Department of Public Safety is where they would find that information.
I understand that. The reason I bring it up is that I know that when I was preparing last night, we're hearing another bill that is similar, that is
Okay.
much narrower, dealing with the rideshare piece. I think your bill, Representative, has a very good chance of passing in whatever. I think we should build that requirement into your bill, Representative Howard, if possible, if it's not already there, to
May I-
require, it is required.
May I, expand
Please.
here? Apparently this is Section 19, Sections 2402.107A and B Occupations Code say that before permitting an individual to log in as a driver on the company's digital network, Transportation Network Company must.
Very
And then
good.
there's a list of things that they must do, which they have to confirm a variety of things, including looking at the state sex offender public website maintained by the Department of Public Safety is what we're trying to accomplish here, too.
Very
They
good.
already have the National Sex Offender public website maintained by the U.S. Department of Justice.
Very good.
Keep
Thank
giving
you,
me notes.
Representative Howard.
You
I
know,
appreciate that.
They are the experts on this. Uber apparently registered in support.
Very good.
Another thing. So I'd be, if we need to call somebody else up, obviously, I'm not the expert on all the legalities here.
Yeah, there's a lot going on with
There
it. and-
is.
But thank you.
And I trust this group
Yes, thank you so
immensely.
much.
Thanks. Any other
Thank you.
questions or comments? Thank you very.
What? No, not y'all.
Oh.
I trust SASTIF.
Yeah.
Let's be clear, Representative Moody, I trust SASTIF, yes.
So if there's no other questions, Ms. Howard, we'll leave the bill. If there's no objection, the chair will leave House Bill 47 pending, but we'll try to act on this
Thank
pretty
you.
quick. I think some of the members have some things they kind of want to check out, but
Sure. I appreciate that.
We know there's a lot of effort. It's good legislation. So if there's no objection, we'll just leave it pending at this time.
Thank you, Chairman.
Thank you, Ms. Howard. And members, at this time, first of all, I was remiss in not doing this earlier, but I need to let everyone here know that if you're here, and we had several register for this bill, House Bill 2895 by Representative Patterson. That bill was on the agenda, but it's been withdrawn at the author's request. And so we may be resetting that bill at a later time, and I apologize for not making that announcement sooner, so that you had to wait through this. But it will not be, 2895 will not be heard today. And so the next that we had distributed a list of bills to vote on today, and so if we'll go ahead and proceed to vote on those. First, the chair would. Where's the list? I know, but the actual what the bills. Okay. First of all is the chair would call up as pending business House Bill 36 by Representative Bowers. And members, this is the bill we heard a couple of weeks ago that relates to monitoring certain family violence offenders and resources for victims and information collection on bonds imposed in family violence cases and other criminal offenses. Ms. Bowers offers a committee substitute that I believe has been distributed. Is there any objection to the adoption of the committee substitute? If not, the substitute is adopted. And then, so Mr. Wu moves that House Bill 36 as substituted be reported favorably to the full House with the recommendation that it do pass, be printed and sent to the Calendars Committee. The clerk will call the roll.
Chair Smithy?
Aye.
Vice Chair Wu?
Aye.
Representative Bowers? Representative Cook? Representative Jones? Representative Little? Representative Louderback? Representative Money?
Aye.
Representative Moody? Representative Rodriguez Ramos? And Representative Verdell.
So by a vote of 11-0, the bill will be reported favorably and referred to calendars. Next, the chair calls up and lays out as pending business House Bill 166 by Representative Capriglione. Members, this is the bill we heard last week that adds fentanyl as a controlled substance in endangerment and abandonment cases involving children, disabled individuals, and the elderly. There's no substitute on it, so Mr. Moody, are you okay with moving that House Bill 166 be, without amendment, be reported favorably to the full House with the recommendation that it do pass and be printed and sent to the Committee on Calendars? Clerk, please call the roll.
Chair Smithy?
Aye.
Vice Chair Wu?
Aye.
Representative Bowers? Representative Cook? Representative Jones?
Aye.
Representative Little? Representative Louderback? Representative Money?
Aye.
Representative Moody? Representative Rodriguez Ramos? And then Representative Verdell.
Okay, so by a 10-1 vote, the bill will be reported favorably to and referred to the Committee on Calendars. Next, the chair lays out as pending business House Bill 380 by Representative Guillen. This is a bill we heard several weeks ago that changes the statute of limitations for prosecuting the offense of improper relationship between an educator and a student, as well as the sex offender registration requirements. Mr. Louderback, are you okay with moving this? Mr. Louderback moves that. Okay, we do have a substitute. Representative Louderback offers the committee substitute, which has been distributed. Is there any objection to the adoption of the substitute? If not, the substitute's adopted, and Representative Louderback moves that House Bill 380 is substituted be reported favorably to the full House with the recommendation that it do pass be printed and sent to the Calendars Committee. Clerk, please call the roll.
Chair Smithy?
Aye.
Vice Chair Wu? Representative Bowers? Representative Cook? Representative Jones?
Aye.
Representative Little? Representative Louderback? Representative Money?
Aye.
Representative Moody? Representative Rodriguez Ramos?
Aye.
Representative Verdell?
Aye.
11-1.
Okay. By 11-0 vote, the bill will be reported favorably and referred to Calendars Committee. Next, the chair lays out as pending business House Bill 502 by Representative Flores. This is another bill we heard last week that allows victims of invasive visual recordings and indecent assault to obtain pseudonyms for use in public files, records involving the offense, so that they don't have to reveal their real name. And so, Ms. Jones, you okay with moving this?
Absolutely, Mr. Chair.
Okay. So Representative Jones moves that House Bill 502 without amendment be reported favorably to the full House with the recommendation that it do pass, be printed and sent to the Calendars Committee. Clerk, call the roll.
Chair Smithy?
Aye.
Vice Chair Wu? Representative Bowers? Representative Cook?
Aye. In here.
Representative Jones?
Aye.
Representative Little? Representative Louderback? Representative Money?
Aye.
Representative Moody? Representative Rodriguez Ramos?
Aye.
And Representative Verdell?
Aye.
11-0.
Which one's that?
160 Capricorn.
Okay. Did you vote no? Okay, I will call it back.
Do you want to do that now? 166?
Yeah.
Okay, sorry, this was 11-0.
Okay. So by an 11-0 vote, the bill will be reported favorably and referred to calendars. Members, at this time, Vice Chair Wu, as one of the prevailing votes, moves to reconsider the vote by which House Bill 166 was was passed a moment ago. And is there any objection to reconsideration? There being none, the bill will be reconsidered, and we'll retake the vote. Clerk will call the roll.
Chair Smithy?
Aye.
Vice Chair Wu? Representative Bowers? Representative Cook? Representative Jones? Representative Little? Representative Louderback? Representative Money?
Aye.
Representative Moody? Representative Rodriguez Ramos? And Representative Verdell.
Okay, so by an 11-0 vote, the House Bill 166 will be passed and referred to the Calendars Committee. Next, we have House Bill 14, the chair lays out as pending business, House Bill 1445 by Representative Hernandez. This is the bill we heard last week that allows the manager to assign council director to designate another individual to approve payments for attorneys who provide indigent defense. There was no real controversy over this one. And there's not a substitute for it. So at this time, Ms. Rodriguez Ramos, you okay with moving this? Ms. Rodriguez Ramos moves that House Bill 1445 without amendment be reported favorably to the full House with a recommendation that it do pass and be printed and sent to the Committee on Calendars. Clerk, please call the roll.
Chair Smithy?
Aye.
Vice Chair Wu?
Aye.
Representative Bowers? Representative Cook? Representative Jones? Representative Little? Representative Louderback? Representative Money?
Aye.
Representative Moody? Representative Rodriguez Ramos? Representative Verdell.
So by a 10-1 vote, the bill will be reported favorably and referred to the Calendars Committee. Next, the chair lays out as pending business House Bill 2066 by Representative Verdell. We heard this last week about the expunction of those placed on deferred adjudication community supervision for the unlawful carrying of a handgun. There's no substitute, I don't think, or amendment, and therefore Mr. Money moves that House Bill 2066 without amendment be reported favorably to the full House with the recommendation that it do pass, be printed and sent to the Committee on Calendars. Clerk, please call the roll.
Chair Smithy?
Aye.
Vice Chair Wu? Representative Bowers? Representative Cook? Representative Jones?
Aye.
Representative Little? Representative Louderback? Representative Money?
Aye.
Representative Moody? Representative Rodriguez Ramos? Representative Verdell. 11-0.
By 11-0 vote. Was that your first vote, Bill, to get out of committee?
That is. Appreciate it.
It's relatively easy. Congratulations. So next, the chair would call up as pending business House Bill 2596 by Representative Metcalf. Members, this is a bill we heard last week that expands the issuance of certain protective orders for certain burglary offenses. There is a substitute, which I think has been provided to the members. And Representative Verdell, you okay with laying out the substitute? Representative Verdell lays out the substitute. Any objection to the adoption of the committee substitute? There being none, the substitute is adopted, and Mr. Verdell moves that House Bill 2596 as substituted be reported favorably to the full House with a recommendation that it do pass, be printed and sent to the Calendars Committee. Clerk will call the roll.
Chair Smithy?
Aye.
Vice Chair Wu? Representative Bowers? Representative Cook? Representative Jones?
Aye.
Representative Little? Representative Louderback? Representative Money?
Aye.
Representative Moody? Representative Rodriguez Ramos? Representative Verdell. 11-0.
By 11-0 vote, then it will be reported favorably and referred to the Calendars Committee. That's all we've got on that. Members, we've got a new procedure in place this session to deal with our bills that we have coming out of subcommittee. And so at this time, the chair would recall House Bill 1831 by Representative Johnson, Representative Ann Johnson, from the Subcommittee on Juvenile Justice, and the chair recognizes Chairman Cook to basically explain the measure and kind of explain what the subcommittee came up with on it.
Thank you, Chairman. The Subcommittee on Juvenile Justice met on March 26th, and we heard House Bill 1831 by Vice Chair Johnson, which expands juvenile eligibility for drug court programs subject to prosecutorial approval. This bill aims to increase the amount of youth who can access rehabilitative treatment and lower long-term costs associated with juvenile detention. The subcommittee voted 4-0 with one absent to recommend HB 1831 be heard by the full committee.
Any objection, members? If not, Mr. Cook moves that House Bill 1831 without amendment be reported favorably to the full House with a recommendation, referred to the Committee on General Calendars and with a recommendation that it pass. Clerk, please call the roll.
Chair Smithy?
Aye.
Vice Chair Wu? Representative Bowers? Representative Cook?
Aye.
Representative Jones?
Aye.
Representative Little? Representative Lauterbach? Representative Money?
Nay.
Representative Moody? Representative Rodriguez Ramos? Representative Verdell?
So by
9 to 2.
9 to 2?
Yes, sir.
By a 9-2 vote, the bill will be reported favorably and referred to the Committee on Calendars. There's one more bill the chair will recall, House Bill 20, the chair recalls House Bill 2147 by Chairman Van Dever from the Subcommittee on Juvenile Justice and once again recognizes Chairman Cook to explain the bill and report the subcommittee action.
Thank you, Chairman. This bill was also heard on March 26th by the Juvenile Justice Subcommittee for HB 2147, which is Chairman Van Dever's bill. This bill will allow courts to conduct juvenile depositions, hearings, and proceedings remotely, working with the Office of Court Administration. The subcommittee voted 3-0 with 2 absent to recommend that HB 2147 be heard by the full committee.
Okay. Any objection to taking up 2147? If not, Mr. Cook once again moves that House Bill 2147 be reported favorably and referred to the Committee on Calendars with a recommendation that it do pass and be printed. Clerk, please call the roll.
Chair Smithy?
Aye.
Vice Chair Wu? Representative Bowers? Representative Cook?
Aye.
Representative Jones?
Aye.
Representative Little? Representative Lauterbach? Representative Money?
Aye.
Representative Moody? Representative Rodriguez Ramos? And Representative Verdell? 10 to 1.
So by a 10-1 vote, the bill will be reported favorably and sent to the Committee on Calendars. So, members, one other thing I need to do is announce the referral of a few more bills to our subcommittee on new offenses and the altered penalties. And so with that, the chair will refer the following bills to the subcommittee. House Bill 1582 by Representative Alders. House Bill 1720 by Representative Gervin Hawkins. House Bill 2095 by Representative Martinez and Representative Wally. House Bill 2113 by Representative Reynolds. House Bill 2135 by Representative Bojani. House Bill 2181 by Representative Shaheen. House Bill 2871 by Representative Josie Garcia. House Bill 2915 by Shaheen. House Bill 3162 by Representative Cook. House Bill 3193 by Representative Reynolds. House Bill 3294 by Representative Reynolds. House Bill 3498 by Representative Cook. House Bill 3507 by Representative Wharton. House Bill 3665 by Representative Harris. House Bill 3869 by Representative Harless. And House Bill 3877 by Representative Bonin. If there's no objection, those bills will be referred to the subcommittee. No. We have one.
I think you misread the number on Cook's 3167.
Okay, I just want to clarify, Representative Cook's bill is 3167. Okay. Yes, I did. So those bills will be, if there's no objection, those bills will be referred to subcommittee. The subcommittee on new offenses and changed penalties. And members, if you all have any bills that you want set on behalf of yourselves or other members, if you will notify either me or the clerks by tomorrow sometime, because we have to post on Thursday, let us know, and we'll try to get those set for next week, especially if you have any of your bills you need to get set. And also, the bills that we've heard, if you can let us know as soon as possible that it looks like the author, whether it's you or another member, has the votes to get it out, we're going to try to continue to get a list out hopefully late Monday, sometime Monday, so you'll have overnight anyway on Monday to look at the bills to be voted out. If anything else, members, at this time or not, otherwise we'll just keep going on, plugging away on these bills. Oh, yes, Ms. Bowers?
Mr. Chairman, thank you. I just want to thank the committee for your vote on voting my bill out today. Thank you.
Now it's up to you. You gotta get
Yes,
that-
absolutely.
Okay,
Thank
all
you.
right. Okay. Ms. Howard, can I call Mr. Paul up? Would you mind? Because he's only got 2 witnesses, and I think it'll go relatively fast. So, which one? Okay, Chair lays out House Bill 1552 and recognizes Representative Paul.
Thank you, Mr. Chairman. Thank you, Representative Howard. Appreciate the chance to lay this out. Members, this is a bill that's brought to me by one of my constituents who's very passionate about this subject and what we could do in this arena. And it's an important piece of legislation that I think y'all would be interested in. House Bill 1552 amends Texas statute to remove the antiquated term child pornography and replaces it with child sexual abuse materials, or CSAM for short. The term child pornography minimizes the severity of the crime and the trauma experienced by children. Child pornography implies participation or consent, which is not legally or developmentally possible for minors. HB 1552 introduces child sexual abuse material, the term widely supported by child protective organizations like the National Center for Missing and Exploited Children. Texas would join 4 states that have taken steps to update the status to accurately reflect this abuse of children. And I know my witness is here, but I'll be glad to answer any questions that y'all might have on this.
Any questions for Mr. Paul? All right, thank you.
All
We'll
right,
reserve the right to close. Okay. Members, I need to do something that I should have done a little while ago, and that's recognize that Ms. Bowers is present. She came in during one of the witnesses, and so I apologize for not recognizing you sooner. The chair calls Crystal Coral.
Yes, sir.
Hi, everyone. My name is Crystal Coral, and I am testifying in support of House Bill 1552. I am a forensic criminologist consultant. I have experience in both criminal investigations and child victim advocacy. This change is not just about...
Let me stop you.
Yes.
State your position on the bill, if you would.
Oh, I'm in support.
Okay. Oh, and
I'm representing myself.
Okay, that's perfect. Okay, I'm sorry.
Sorry.
Thank you. I didn't mean to interrupt you.
No, sir, it's fine. So this change is not just about words, it's about justice. The term child pornography is inaccurate and extremely harmful. The word pornography implies consent and is legally defined as erotic material that involves consensual adults who participate in sexual explicit acts or imagery. The term child pornography lacks the true meaning of this unspeakable crime, as the words fail to convey the reality that these materials are not just illicit content, but are documented evidence of a child's sexual abuse and exploitation. The term child sexual abuse, which would hold the acronym CSAM, correctly identifies the crime for what it is: the documented rape, trauma, and exploitation of a child and or children. Science and law both affirm that children cannot consent to sexual acts or exploitation, and neuroscientific research confirms that a child's brain is not fully developed to comprehend or consent to sexual acts or exploitation, which in hand reinforces the legal scientific consensus that children cannot provide informed consent in these matters. Yet, by continuing to use this outdated terminology, we undermine the victims, the survivors, and the fight for justice. We all understand that words have meaning, and it matters how we use them properly.
This new updated terminology will help shape perceptions, influence prosecutions, but most importantly, impacts the way survivors and victims are treated. This is more than a technical revision. It is a crucial step toward ensuring that our laws accurately reflect the gravity of these crimes and center on the protection of children. Again, words matter, and adopting the correct terminology strengthens our commitment to combating child sexual abuse and exploitation. I urge you to pass this bill so that Texas can take a clear and unwavering stand against these crimes. Let us support victims and survivors in the pursuit of justice. Thank you for your time.
Thank you. Members, any questions? Mr. Little?
Yes, sir.
Thank you, Ms. Coral. I'm familiar with the kind of the shift toward using CSAM as an acronym, or at least language around this problem. I don't understand why the term pornography implies the consent of a child. I don't understand it. Can maybe you explain it to me?
So you're saying that the word child pornography implies consent?
My understanding is the reason we're changing, or the reason we would like to change this from child pornography to CSAM, is that the term pornography suggests that a child is somehow complicit in whatever illegal activity is going on, and I just don't understand why that is, or why we would presume that that is.
I just believe that with media nowadays, the word pornography, child pornography, doesn't have that effect to really define what is currently happening to children who are being exploited, and these images that get sent out and continually rotating. It's just child pornography literally just kind of like waters it down for what it truly is. So that is why it's important that we acknowledge it, to call it child sexual abuse material.
Is this going to make anybody safer?
I believe so, because I'm in Houston, so we currently have sex offenders that live in my neighborhood that do have the crimes of child sexual abuse material. However, their prosecutions it's kind of, to be frank, it's like slap on the wrist. Nobody really sees it as a serious crime for what it really is.
Yeah. Well, I certainly see it as a very serious crime. I don't know why changing the language is going to make anyone safer, or why the use of one phrase or another suggests or implies anything a child did or didn't do. So I'm confused.
No, I respect your
do you
thought.
see it clearly?
Yes, I do. I mean, other states have already adopted it. I feel like Texas it's 2025, and I feel like it needs to be updated in that kind of term.
Okay.
Any other questions? Okay. Mr. Wu?
Let me see if I can help out a little bit. So, no, we're not talking about approval or anything, but like adult pornography is generally consensual, correct?
Yeah.
Like, so adults consensually engage in it and film it or whatever else. Is the implication that calling child pornography the same thing pushes it into that category in the minds of somehow these kids like agreed to do this, right? And to call it something else is an attempt to at least rhetorically detach it from the concept that adults make legal and consensual pornography, right?
Yes.
Right. Okay.
Okay. Anything else? Ms. Jones?
Along those same lines, I think that pornography sort of sanitizes it. I think people hear pornography so much, they really don't think about what pornography is. And one of the ladies who came up here before on the other bill, I'm not talking about that bill, but when she was saying this is ugly, like these things we're talking about, they're ugly, they're not pretty, they're not sanitized. I think when you call it sexual abuse material, when it relates to kids, it puts the focus not necessarily on the picture or that sanitized version, but it tells people this is abuse.
Yes, ma'am.
And at least that's my interpretation of it.
No, and that is correct. It is the literal rape, abuse, and trauma. And you have to understand, I have had a case that happened when floppy disks were available, and it's currently being circulated of this child's rape, who her uncle videoed her performing, acts with her. And she's 40, and she still has those images available to this day.
And I'll say this, I've shared that I was what they call it when people get charged with crimes, they'll call it sexual assault or they'll say molestation, right?
ma'am.
They'll say something like that. And that really is sanitized as well, right? So I was trying to figure out how to explain to people what happened to me when I was 3 and my uncle was 6'7". I mean, use your imagination.
Yes, ma'am.
And all I could come up with is like I was brutally raped as a 3-year-old. And, but people just don't think of it. So I just think that retitling it makes you focus on the sexual abuse aspect of it and not a nice word for something.
Exactly.
So I'll be voting for it just because
Thank
I think
you
it
so much,
helps. It
Representative
helps
Jones.
put the focus on the abuse.
Absolutely. I appreciate that. Thank you.
Okay, anything else, members? Yes, Mr. Money?
I absolutely agree that child pornography is child sexual abuse, and I understand what's trying to happen here. To me, when I hear that someone has pornography on their computer, I have an idea of what that is, and when they say child pornography, that does horrify me, and maybe I'm in the minority in that. I don't know, but to me, I immediately that doesn't sanitize it for me. You put child in the front of that, and it is shocking and astonishing to me. I'm concerned, and we're talking about semantics here, and I think everybody wants the same thing. I don't think from the bill author to everyone on this dais, we want there to be a stigma attached to people who are in possession of this kind of material, looking at this kind of material, and that sort of thing. But when I hear child sexual abuse material, I know it's bad, but I don't know exactly what it is that I'm hearing. At least I don't. I know it's bad. I'm against it. I don't want it, but I don't. But when I hear child pornography, I have an idea of what that encompasses, and so I'm just having a hard time understanding that this is a significant improvement from where we were, or from where we are today, because I don't see it as a sanitary term, and I might be in the minority there, but that's just how I feel.
Anything else? Yep. Ms. Bowers?
Thank you, Mr. Chairman, and thank you, Representative Money. Like, I really don't understand either, because when you say child pornography, you definitely know what that means. Like, I may need to ask the author, but what is the real motivation behind changing it to child sexual abuse material?
It's because you're calling it for what it really is. It's not just child pornography, and there's other words that people have called it, kiddie porn. It's literally.
But using the word, and I don't mean to cut you off.
No, ma'am,
because
it's fine.
I try not to be rude to anyone in
No,
here.
it's fine.
But child pornography, to me, in a nutshell, says what it is.
Yeah,
right?
and that's to some, and then there's others that don't really look at it as being, wow, that's really what it is. Because we're talking about children who are trafficked and then they end up being on these websites, sexually abused. And we're not talking just regular, this is real trauma. This is real awful.
So does it not lessen the blow to say child sexual abuse material from child pornography? Does it not lessen the blow of what that is?
No, I don't believe so. I believe it really emphasizes on what the situation is.
Well, I certainly beg to differ, and I do think that Mr. Money and I are in agreement. Like, are you saying that it should be child pornography, or are you saying that it should be child abuse, sexual abuse material? Wait for the chairman to recognize.
Go ahead, Joe, go ahead.
Yeah, to me, it's more complicated. The new terminology is more complicated to me.
Agreed.
And I think that the current terminology is stigmatizing in the right way. But that's just my opinion. So.
And Mr. Chairman, may I go?
Yes.
Thank you, because I believe in protocol. Mr. Money, absolutely. And Mr. Paul, Representative, like, we should talk with you about this, because I certainly do believe that it says what it is. If we say unfortunately, we've had pornography in our society for way too long. For one day is too long. But pornography of any kind, and when you put the word child in front of that, that is what it is. So I feel that saying now that it's going to be child sexual abuse material, it's not as strong as saying child pornography.
Okay, I respect that.
And I want to hear what your thoughts are since you know, given your testimony. I want to understand it.
No, and I fully understand what you're saying. However, I still strongly believe that calling it for what it really is, the child sexual abuse of a child, that's being, these images, material things that are being sent out. To me, child pornography doesn't have that attention that like, oh, wow.
But you do know what pornography is, right?
Yes, I do.
So when you put child pornography, then that should, in a nutshell, say what it is. I just don't see why you need child sexual abuse material.
Because I believe that we need to call it for what it really is, not just saying child pornography. We need everybody to understand that this is a child sexual.
Do we have statistics, and maybe Mr. Paul does, on how many people don't understand what child pornography is?
No, I don't have statistics with me, but there are several other states, along with federal agencies, along with National Center of Missing and Exploited Children, that have already adopted this phrase, this legal terminology. I just believe that Texas should be part of one of those states that adopt this terminology.
And who do you have the list of those states that you could share?
Yes, so we have states, a few states like Florida, New York, California, Illinois, Maryland, Maine, Massachusetts, Oregon. So I believe that, why not Texas?
All right, well, I'm going to let this go for right now, but I would love to talk to you about it at another time. Yep.
Mr. Latterback.
Ms. Carl, thank you for your testimony. I'm concerned mostly about this. This is some terminology that makes it not sound as bad. So I'm worried about what juror is going to know what CSAM is. And so there may be an education process, but I'm just wondering exactly how effective we're going to be at trial with a jury on a case. So that's what concerns me about.
No, and
I mean, we need convictions here.
Mhm.
So is this going to help convictions or
Yes,
hurt them?
sir. I strongly believe it will, because people are really going to see.
I'm in that camp. I disagree. I'm
Okay.
afraid that our public and our jury pools that we're selecting are very consistent with what child pornography stands for. So I'm concerned about this.
Okay.
Thank you.
Members, any other questions? Representative Cook.
Thank you, Mr. Chairman. I'm generally a regular subscriber to a Paul bill is a good bill, but I have the same concerns on this one as well. Do you participate in CPS cases?
Oh, no, sir.
No, okay. My experience as a family law attorney, and I'm not a criminal lawyer, but as a family law lawyer, I mean, you can have child abuse, but it may not be criminal in nature. So you have a civil matter versus a criminal matter. And I cannot imagine child pornography in any instance except as a criminal matter. And so that's why I think when you say child abuse, I mean, I can't even, without looking at it, child porn definitely sticks, to me as far as which one's going to have, I guess, to use Mr. Money's words earlier, more of a stigma. I mean, I think that's what calling it is what it is, is that it's child pornography and it's never legal. I mean, it's always illegal. And child abuse can, sometimes doesn't rise to the level of a crime, and that's why I think abuse is less, I think child pornography says what it is, so that's my comment.
Can I ask a question?
Of course.
So do you think it's because the word itself, it's too long, than not eye-catching?
I think both. I think abuse, because I think you can have abuse. You can have abuse or neglect without it being a crime, and I want people to know that child pornography is always a crime, never ever anything but a crime. And abuse can be something that's not desirable, but it may not be illegal. It may not be a crime.
Okay.
So that's my thought.
No, it's okay. I
Thank you.
appreciate it.
I appreciate you being here and appreciate
Yeah,
your
thank you.
expertise.
Money.
No, I'm sorry. I was just going to say, it's as simple as like child porn's 2 syllables, child pornography 5 syllables, child sexual abuse material 10 syllables. It's just not as punchy to me but I'm a simple-minded person.
Rodriguez Ramos.
Quick question. You said the National Center for Exploited Children uses this terminology.
Yes, ma'am.
What does the DOJ and the FBI use? Do they?
So I believe that they do use that. I know the FBI. I'm not sure about the DOJ.
Okay. All right. Thank you.
You're welcome.
Rep. Bowers.
I guess I'm still stuck on it. While I appreciate, Mr. Chairman, thank you for recognizing me. While I appreciate this testimony and any colleague of mine that brings a bill to this legislative body and legislature, I do agree that most Paul bills are good bills, most often. But I'm still stuck, and I do have to question, really what that means. So I need to see the list of those states.
Yes,
so,
ma'am.
like, if you could get that,
I can
to
get
me.
it.
Yeah, because I hate to question y'all, and I really don't like to drill down on people's bills, but it's not sitting well. So,
Okay.
thank you.
No, thank you.
Members, let me see if I can help out just a little bit. Child pornography, the term is common vernacular. It is street. Like, it's just something that we just generally just made up a name and called it that, and we threw it into the law. This is a term, this is a scientific and legal term that is now being used to replace this. I do work in the CPS world. I do work in child abuse. This term is now replacing child pornography because it is a more complete and accurate term to what it is. Some of the materials taken with children are not pornographic in nature, meaning that there's no nudity, there's no sexual acts, but it is still abusive. And you can see it in the thing, and either the child's being groomed or the child is being sexually assaulted over their clothes or something like that, right? That would not necessarily be pornography in the legal sense, right? So this is a more complete and accurate statement that is being changed across the nation because it is a legal and scientific term of art, right? It matches up to specific legal codes.
Thank you.
Rep. Ramos, Rodriguez Ramos.
Thank you. And I just looked it up. Both, apparently the FBI issued a statement in 2022, or the Department of Justice, that this is a term that they felt more suited, and so did the FBI. So that was a couple of
Thank
years
you, ma'am.
ago.
I
Yes.
don't have a computer. Thank you.
Yes, ma'am. Okay, thank you.
No, thank you.
Rep. Bowers.
Okay, thank you, Mr. Chairman, and thank you to my colleague down at the other end of the dais, to Rep. Rodriguez Ramos. So you're clarifying as well that the FBI has decided that this is the term that should be used. Will they be synonymous, one and the same? It doesn't sound like they're one and the same. They are not, correct?
I believe that it is an updated term that is the same.
Okay, but I'm asking you, is this what is going to happen? That it is going to be child pornography equals child abuse, sexual
Yes.
abuse material?
Yes.
And is that what you're saying? Because you look like you're saying that's in a nutshell what it's simply
Yes.
saying. Okay. We're just trying to make sure.
No, ma'am, I understand.
I mean, because I would hate for people not to understand what child pornography means. So
No, I understand.
I guess
Anyone
that's
else?
it for me. Thank you, but I do see some more.
Ms. Jones?
And I'll say this, as a lawyer who tries cases, and there's a definition of whatever it is, right? And that the state or the government has to prove beyond a reasonable doubt that every element of the offense happened. So when you have this, there's going to be a definition in the jury charge that's going to define child sexual abuse material, right? So it's not going to be like somebody's out on the street trying to wonder what it is. In the jury charge, after both sides have argued their sides and given their closing, there's going to be a charge that says child sexual abuse material means an image of a child engaging in sexual conduct or sexual performance. So the people that are going to be deciding or determining a verdict, they're going to know what it is.
Yes.
I'm just putting that out there for the universe. So, for the universe. So, because there's a lot of times you don't rely on common vernacular. There's like a legal definition of what whatever it is. So I think that anybody, or at least me, if I read this, I'd be like, oh, that sounds like child pornography, right? But in any case, for those who don't know, whoever's making the decision about whether somebody did it or not, they're going to have this definition.
Absolutely.
And I think they're going to be very disgusted by it.
I agree.
Is what I think, in any case.
Thanks. Anything else? Ms. Bowers?
Yes, and for the universe, thank you, Mr. Chairman. But for the universe, I am not a criminal attorney. I am a mom, period, full stop, right there. And when I hear child pornography or child sexual abuse material, and I think Mr. Little knows it as CSAM, like he's that far deep into the legal world and profession that he knows some stuff I don't. But as a mother sitting right here on this dais, to me, child pornography is what it is. And that's why I've been going back and forth and have been stuck on it. And now I am the universe saying that, praise God for Representative Jones, Jolanda Jones, that she said they're going to have a definition right there, right?
Yes, ma'am.
Because as a mother, I wouldn't have, I hear child pornography and I'm like, that's just wrong. So I didn't need CSAM, but whoever needs CSAM, now that I know that that's what it is, and y'all are going to provide the list, the universe, all is well with the universe. Okay. Thank you.
And if it helps, ma'am, I'm also a mom. My children are watching, so.
Well, tell them hello for us. And, yeah,
Thank you.
And you probably had no idea when you came up here you were going to be.
No.
It was so long. So
But it's okay. I gave them a show,
well,
so.
we try to be respectful to civilians particularly. So thank you for being here
Thank
today.
you.
Okay. Members, we also have, and let me just say, Mr. Verdell has asked to reconsider a vote in a moment that he had voted. He wanted to vote yes on Ms. Johnson's bill, and so if you'll kind of hang tight here, we'll try to get everybody back and vote on that. So anyway, so the chair calls Jean Petit.
Hi, everybody. I know it's been a long day, so thank you for your
Not
patience.
Yet,
It's getting there. Thank you, Chairman Smithy and committee members. My name is Jean Poteet, and I am testifying in favor of House Bill 1552. Thank you, Representative Paul, for filing this bill. I'm here on behalf of a nonprofit called Not on Our Watch, which is an initiative of Texas Women in Business. We are rallying women in business across the state to raise awareness of online abuse, exploitation, and sextortion to help protect children and youth. There are many of our members watching this hearing online and from their homes or offices throughout the state. We're excited to voice our support of House Bill 1552, changing the language from child pornography to child sexual abuse material, also referenced as CSAM. It is important to recognize what is really happening to these children: abuse. CSAM images are often referred to as child pornography, which can be misleading and imply consent like adult pornography. However, these children are not consenting to anything. They are being exploited and abused. More accurately, they are being raped. Many international organizations and child protection advocates are already supporting the use of the term CSAM to promote a more consistent and accurate understanding of the issue globally. Additionally, the language used could affect how current and future laws are interpreted and enforced. By using terminology that clearly conveys the abusive nature of the material, laws may better reflect the seriousness of the offenses and impact on victims. In summary, we support House Bill 1552 and advocate for updating the terminology from child pornography to child sexual abuse material because we believe this is a crucial step in recognizing the severity of the crime, advocating for the rights and dignity of child victims, and ensuring that their legal frameworks accurately address the exploitation and abuse of children. Thank you for your time.
And thank you. Any questions, members? Thank you for being here today.
Thank you.
You got off easy, though. There's an advantage to going second.
You already got the other question.
Okay. So anyone else here to testify for, against, or on House Bill 1552? If not, Representative Paul, you want to close?
Yeah, I appreciate it. Thank you. I know that the two witnesses end up going along there, but y'all's point, I do want to point out a couple things. Even Mr. AI here was showing me on his phone when he pulls it up real quick. It just said, hey, pornography could be about anything, but it's clear that sexual abuse is abuse of children. That was in a 2-second thing right there. In fact, the U.S. Department of Justice says child sexual abuse material is preferred as it better reflects the abuse that is depicted in the images and videos of resulting trauma to the child. On Facebook, they removed 6.2 million pieces depicting child sexual explicit content and 2.5 million pieces of child nudity and physical abuse content in the fourth quarter alone last quarter. So by having this terminology, the abuse, we're going to make sure that we're going to be able to catch it. It's going to show that what's really going on is abuse. And the bottom line is, I think when we make clear that we're prosecuting for your abuse, we're going to be able to hopefully put more severe penalties on these people that are doing this sick behavior. And it does, Representative Bowers, it looks like a 35-page bill. That's because it's making sure that those terms are already through it all, so it will capture all that. And the bottom line is, we think of child pornography because we're used to using that term because it's a term that we're used to. But once you really start looking at what's going on, this abuse, and making sure we capture that abuse, you can see this is actually a good thing to go and change and make a move forward.
Okay,
So
any questions?
Ask for y'all's support.
Okay. Thank you, Mr. Paul. Oh, I'm sorry. Ms. Jones?
This is something I was just thinking, and I think it goes to your point. When most people, if they think of child porn, they think of a picture. Like, they think of a picture. But you don't think about what they were doing to the kids. Did they force the kids to do stuff? And so I think just like we didn't know what AI was before Facebook, we didn't know what Facebook was. I mean, before smartphones, we didn't envision that. And so I think that this is an effort, you can correct me if I'm wrong, Chair Paul, that it's an effort to sort of modernize.
That's right. We're going to modernize to show that this is abusive behavior, and these people are tortured. And like she was saying, somebody had an image for 40 years. They have to deal with this. This image is out there. So I think this is really much in line. I mean, my first thought of it is, hey, what is this? Just kind of y'all's first thought. The more you really look into it and you hear what our witnesses testifying, how it's important to them, I mean, you can see that this really is something good we should move on forward. Let's let Texas be the leader on this. The other big states have done it. Let's do it and move forward.
And again, it says sexual abuse, right?
It's abuse.
Right. So anyway,
I
thank
think
you.
it'd be great.
Okay.
Thank
Any
you,
other
Mr. Chairman.
Okay. And so we appreciate you. You got anything else, sir?
No.
Okay. So
close.
With that, we'll leave the bill. If there's no objection, we'll leave the bill pending, and maybe Ms. Paul, you can work on it with some of the members. So House Bill 1552 will be left pending. Mr. Capriglione, I told Ms. Howard I'd get her back up. We had to interrupt her a moment ago. But, okay, before I do that. Does anybody, can everybody stay through this one bill because, to do the reconsideration? Are you okay? Okay. Let's do this bill and then we can do that reconsideration. Hopefully get Mr. Cook back. Miss, no. What's that? Yeah, it's Ann Johnson's. Okay, Ms. Howard, I'm sorry. So at this time, the chair would lay out House Bill, I apologize, 3073 and recognize Representative Howard.
Thank you, Chairman Smithy and members, for the opportunity to lay out House Bill 3073. Similar to other bills, especially even earlier in this particular hearing, this layout is particularly significant because today is the beginning of Sexual Assault Awareness Month. According to the Texas Association Against Sexual Assault, 2 in 5 women and 1 in 5 men in Texas have been sexually assaulted. The Rape, Abuse, and Incest National Network estimates that out of every 1,000 sexual assaults, only 230 are reported to the police. 46 will lead to an arrest. 9 cases get referred to prosecutors. 5 will lead to a felony conviction. And only 4.6, I don't know how we get to the 0.6, but anyway, 4.6 rapists will be incarcerated. In Texas, data from the FBI shows that in 2020, over 13,000 rapes were reported to Texas law enforcement agencies, but only 3% of those got a full investigation and trial. This is why HB 3073 is paramount. Far too often in our state, perpetrators of sexual violence are not held accountable for their actions because our laws do not adequately reflect the experiences of crime victims and do not provide a clear definition of how consent is to be communicated and understood. This is the urgent crisis that House Bill 3073 seeks to address. This bill is a top priority for the Governor's Sexual Assault Survivors Task Force, and I am honored to author this bill along with my Senate companion author, Senator Angela Paxton. Before I begin my layout, I'd like to clarify, excuse me, Mr. Chairman, there was a committee sub.
Oh, there is a committee substitute, so Mr. Wu will lay out the committee substitute.
Thank you.
Okay.
Appreciate that. And just to clarify, the committee substitute just omitted some apparently confusing language, put in original language back in, and that's basically it. Okay. I wanted to clarify one common misperception about the Texas Penal Code. When the Penal Code references sexual assault, it is talking about rape. This is not to be confused with indecent assault, which is commonly known as groping. House Bill 3073 is not talking about indecent assault. It is about sexual assault, which again, per statute, is synonymous with rape. House Bill 3073 makes important and necessary updates to the state's consent laws, and we just mentioned the committee substitute, so got that cleared up. First and most importantly, House Bill 3073 provides clarity on the definition of consent, aligning it with the definition used throughout the rest of the Penal Code. As y'all know, I'm not a lawyer, so in layperson's terms, the Penal Code's definition of consent means that consent is given voluntarily and actively and can be either explicitly stated or communicated through actions. House Bill 3073 also adds that sexual assault is without consent if the actor knows or reasonably should know that the other person is intoxicated or impaired by any substance and cannot give consent. When drugs or alcohol are involved, current law states that the actor must intentionally impair the other person by administering the substance. Thus, those who are intoxicated on their own volition or who are drugged by one person but raped by another are not protected. And finally, this bill further clarifies that consent can be withdrawn once an act has been initiated. Consent is not a one-time event, but an ongoing process involving continuous communication and mutual agreement. Current Texas law does not acknowledge a person's right to revoke consent at any time. House Bill 3073 does what current law fails to do. It encompasses the essence of what a sexual assault is. It's a theft. It is a theft of what is most precious to each and every one of us, our person. Texas law already recognizes that a person commits theft if they take something without the owner's effective consent. In other words, we require the presence of a yes, not the absence of a no, to define theft. If a person is drunk at a bar and another person steals their wallet, we will all agree that this is a theft. The thief would not be able to defend themselves by saying that the person was drunk and seemed to be okay with them taking their wallet. However, if a person is drunk at a bar and another person takes advantage of them sexually, current law allows for the perpetrator to defend themselves by saying that they were drunk and simply didn't know that it wasn't okay to do. This disgusting loophole in the law must be closed. Instead of placing the burden on the survivor, we should focus on whether or not the offender had consent to have sex with the victim in the first place. I would like to note that effective consent is currently used as the standard to determine if a person gave someone the necessary consent to use their property, their vehicle, their coin collection machine. Multiple other states have similar provisions in their laws concerning sexual assault, specifically relating to intoxication of the victim and the right to revoke consent. These are not liberal blue states I'm talking about. These states include Oklahoma, Arizona, Idaho, Kansas, Montana, North Carolina, and South Dakota. I want to reiterate what I said at the beginning. 2 in 5 women and 1 in 5 men have been sexually assaulted in Texas, but fewer than 3% will ever see their abuser behind bars. I urge you to join me and the governor's task force in supporting this bill that will hold rapists accountable for their actions and protect future victims. I'm happy to try to answer any questions here. I reserve the right to close. I know there's some witnesses.
Thank you, Ms. Howard. You know, we have heard, as you mentioned, similar legislation, and we've gone through some of these issues. Last week, I think, and unfortunately, I don't think we had this bill referred or something. It's hard to do both of them at the same time, so we apologize for that. So, but we appreciate it, you're bringing the bill. Appreciate your witnesses. Any comment or question? Mr. Little?
Thank you, Chairman Smithy. Representative Howard, I spent a bunch of time with your original bill last night, and I'm looking over the committee sub. Can you just share the reasons for the committee sub? Because there were some pretty significant changes from your original bill, and
My understanding of it is that what it did is it removed incapable of appraising the nature of the act or resisting it and just keeps the unaware that the sexual assault is occurring. That part of this had to do with some confusion that was apparently expressed by some over the language there. And so just returned it to the original language because it didn't seem to really be something that was significant enough to keep that language in when that's not what the intent here is to define consent.
And I'm struggling to understand, so the addition on B3, which is, it is now or unaware that the sexual assault is occurring. So the bad actor has to know that the other person is unaware that the sexual assault is occurring under your change. And I'm trying to understand what the bill is targeting, because it makes sense that a bad actor would know that the other person is unconscious. I don't know what we're trying to pick up with or unaware that the sexual assault is occurring. Like, how is that different from unconscious, and what is it that we're trying to pick up? Do we know?
I'm trying to understand your question, so let me just see if I can look at the language here. I don't think I totally understand your question.
Yeah, I'll try to ask a better question. I'm struggling to ask it too, but we're trying to, your addition or unaware that the sexual assault is occurring, what are we trying to pick up through the addition of that phrase that we don't have right now, either through unconscious or something else?
What I'm going to ask is that we let one of the experts respond to that.
Okay.
If you could, please.
We already took a really hot lap on this, the concept or
Right.
the rewrite with Representative Ann Johnson.
Right.
I'm still trying to grasp it myself, so that might be helpful.
Okay, thank you.
Any other questions? Okay, thank you, and we'll give you the right to close.
Thank you, and I would suggest Summer Willis be called up first if possible, Mr. Chair.
Will do.
Thank you.
Okay. Chair calls Summer Willis.
Hello,
Welcome.
my name is Summer Willis, and I'm here representing myself in support of House Bill 3073. Thank you, Chairman Smithy, Vice Chairman Wu, and the committee for having me here today. Last week, I stood before you as an advocate and an endurance athlete. Today, I'm returning as one of the thousands of survivors in Texas whose bodies became crime scenes, whose stories remain untold, and whose justice remains denied. First, I want to address the concern about intoxication. On the night I was raped, I wasn't just drunk, I was targeted. While fraternity brothers competed over who would get to take me home like a trophy to be won, one handed me a drink that turned my world into a blur. My last memory isn't of consent, it's of desperation. Running, falling, cutting my knees and my hands, a memory of searing pain that briefly pierced through the chemical fog. I woke up, confused, naked, violated. When I asked what happened, my rapist laughed. He laughed and told me what he had done. Days later, the worst thing that ever happened to me was documented in their fraternity newsletter, distributed like the trophy announcement it was. I know there are concerns about what happens when both parties are impaired by alcohol, but let's be clear, alcohol didn't pin me down. Alcohol didn't ignore my incapacitated state. Alcohol didn't strip me naked, and alcohol did not brag about my violation, my rape, afterwards. People make mistakes after drinking too much. They say something embarrassing. They send a regrettable text or wake up with a hangover. But there is a chasm of difference between a regrettable choice and predatory violence. Alcohol does not get to be a get-out-of-jail-free card. Alcohol should not keep this bill from passing. Secondly, I've heard concern about false reporting. These concerns are inflated by sensationalized media and schoolyard hypotheticals, despite consistent evidence showing that false rape accusations occur at rates no higher than other violent crimes. But we never hear concerns about false reporting when it comes to crimes like robberies or home invasions. Instead, in those spaces, we allow the law to focus on protecting the innocent. Here's my closing statement, sorry. I'm not just asking for your vote, I'm asking you to look survivors in the eye, the ones you know, whether they've told you or not, and tell them whether Texas will continue to be a state that leaves consent dangerously undefined, where survivors are left wondering if their rape even counts. Thank you.
Members, do you have any questions? Rep. Little.
Thank you, Chairman Wu. Summer, thank you for sharing your story again with us. I think after having taken a couple passes with this, I think I'm starting to gain a better understanding of what's really a very complex statute. In your situation, I think you spoke about this last time and a little bit today, it seems that the primary problem with the statute is that unless the bad actor caused the impairment, meaning unless the bad actor personally administers the drug or gets that person drunk, there's not criminal culpability. Isn't that really the key
Correct.
issue? So
Yeah.
I think in Representative Howard's bill, her committee substitute, which is different from the one that I reviewed last night, B6, I think that's the rifle shot right there. The actor knows or reasonably should know that the other person cannot consent because of intoxication or impairment by any substance. So if I'm hearing you correctly, the purpose of the modification primarily to the statute is to protect a victim from a bad actor when that bad actor is not the one who intoxicated the victim, but it's some other third party. Isn't that what we're dealing with in targeting?
That's one of the situations, yes, sir.
Isn't that the primary concern of what we're trying to address, is to protect people who have become incapacitated for some reason that is not attributable to the rapist? Isn't that right?
Yeah, and I think it also covers people who are intoxicated.
Or maybe by their own.
Out of their own volition, and then they end up getting raped behind a dumpster at Stanford or bruised at the Harvard campus. My advocacy is around college campuses and realizing alcohol is drunk, but that does not equal consent for that person.
And I think just hearing your story a couple of times helped me really understand that. I think B6, the modification to B6 in the committee sub is the bullseye. I think it addresses that issue particularly well. So thank you.
It makes me really happy that my story was able to shed some light on
Yes,
this.
ma'am.
Thank you.
Any members? Thank you. I just want to ask you a few questions, and just to be clear, I think, and if you can't address these, I'm sure Rep. Howard can. Like, this is, we're not doing this bill because you're asking for it, right? Like,
Yes.
this is a nationwide movement to change these laws because it's been decades since we've realized that these were problems, right?
Right.
Okay. And this bill is being worked on not only by the reps, but also by a lot of lawyers in the governor's office and around here. Like, this is something that everyone is paying very close attention to, correct?
Yes, it's something we really need to change in Texas.
Thank you.
Thank you.
Members, any other questions? Next is Samantha McCoy. And I show you representing yourself,
Yes,
and you're testifying for the bill. Is that all correct?
correct.
Thank you very much. Please proceed.
So thank you so much for your time today. I'm here to testify in support of House Bill 3073, which clarifies the definition of consent. My name is Samantha McCoy, and I'm here as a survivor. For far too long, survivors of sexual violence have faced impossible barriers in their pursuit of justice. Barriers that have emboldened perpetrators, silenced victims, and left communities vulnerable. During my junior year of college, I unfortunately had a very similar experience to Summer, who was just up here. I was physically beaten and violently raped while I was unconscious. Within days after the attack, I would additionally find out that the perpetrator had filmed the rape and disseminated the video online and to people I knew as a way to further re-victimize me. Horrifyingly, the video plainly showed that I was not moving, not responding to anyone or anything. I made the terrifying decision to report the perpetrator to law enforcement because I could not live with the thought that he would possibly do it to someone else. Without any advocate or support person, I made a report, underwent a rape kit examination and photographs of my injuries, and complied with every request that investigators made, including countless and repetitive questions, and painfully having to wiretap the perpetrator without any guidance or forewarning of how terrible it would be to hear the person who had just beaten and raped me on the other end of the phone. Despite my efforts of undergoing traumatic treatment by law enforcement, who asked me questions such as, quote, "If you were unconscious, then how do you know you didn't consent?" In the end, the legal system turned its back on me. No charges were filed, no justice was served. I was left with the fear, knowledge that the attacker remained free, and the horrifying realization that our laws have failed to protect victims like me. Current Texas law states that the perpetrator must intentionally impair the other person by administering a substance. House Bill 3073 strengthens the definition of consent to include when the perpetrator knows or reasonably should know the victim cannot consent to by intoxication or impairment of any substance. Had this law been in place when I was assaulted, I believe justice would have been within reach. Survivors deserve better. We deserve laws that acknowledge what happened to us and hold perpetrators accountable. Restoring faith in our judicial system means ensuring that every survivor's voice matters. I urge you to advance House Bill 3073 for every person who finds the courage to speak out, protect others, and demand change. Thank you.
Members, any questions? Thank you.
Thank you so much.
Next is Nicole Martinez. And I have you testifying representing the Governor's Sexual Assault Survivors Task Force, and you're neutral on the bill as a resource witness, correct?
Yes, sir.
Please proceed. Members, are there any questions for this resource witness? Could you tell us a little bit about the work in the Governor's Sexual Assault Survivors Task Force and how this bill was brought about, what kind of work groups were put together, and who was a part of those things?
Absolutely.
Thank you.
Vice Chairman Wu. Again, my name is Nicole Martinez, and I am the administrator of the Governor's Sexual Assault Survivors Task Force. As Representative Donna Howard mentioned earlier, the task force was established in 2019. We have 26 members of various state agencies, statewide coalitions, and professionals and disciplines who interact with survivors on various levels. Also, the task force has 12 focused working groups, and those focused working groups are smaller groups of task force members, subject matter experts, advocates, survivors, and victim family representatives. They meet as needed to discuss complex topics such as consent. One of our focused working groups is the prosecutor working group, which has been established probably about 4 years and has representation from various district attorneys' offices to include Brazos County District Attorney's Office, Harris County District Attorney's Office, Dallas County District Attorney's Office, Tarrant County, DA, Smith County, Williamson County, Jasper County, Gregg County District Attorney's Office, and the 81st Judicial District Attorney's Office. Including those prosecutors that serve on the prosecutor working group, we do have survivors who, one is present today, Lavinia Masters, and a mother, Tracy Matheson, the mother of Molly Jane, and the founder and president of Project Beloved, the Molly Jane Mission. These individuals and subject matter experts have met for the past, again, 4 years, talking about how can we, as a statewide task force, make amendments to the current statute for sexual assault offense. How can we ensure that survivors, when they report to law enforcement, their case will be accepted by the district attorney's office. As we've heard earlier, the stats for those survivors who choose to report are very few. Those who do choose to report to law enforcement, very few cases are picked up by the district attorney's office. And if they are, very, very few are prosecuted successfully where those offenders are held accountable. So these prosecutor working group members, again, combed through our current statute as well as other state statutes to determine the best way to empower prosecutors to be able to successfully prosecute these types of cases. As mentioned before, this bill, as with the committee substitute, will allow prosecutors to hold those perpetrators accountable and have a clearer understanding of what these circumstances, how they happen, and be able to provide justice for survivors.
Okay, thank you. And Mr. Little?
I think
Oh, I'm sorry.
Representative Ramos had a question.
Sorry.
Thank you. Oh, I'm sorry.
No,
Did you
go-
need to recognize me?
Oh, no, go ahead.
Okay.
Is that okay, Mr. Little?
Please.
Will you defer to
Please.
Ms. Rodriguez-Ramos?
Yes, sir.
Okay,
Thank you. In addition to what the Sexual Abuse Task Force is doing, and you mentioned earlier, and then the stats show it, that people do not report or traditionally don't report it sufficient numbers, and I know this legislation is to help advance that. What are some other initiatives that the task force is doing to encourage more reporting so that there could be more meat to this legislation? We have passed previous bills to mandate law enforcement training so that they have a better understanding of what trauma looks like and how to better interview and investigate these types of cases. We have also passed legislation to require emergency department staff to have a better understanding of what sexual assault is and the dynamics
as well as trauma. We have enhanced the certification for sexual assault nurse examiners, as well as improved their training. I could go on and on and on, but we aren't just tackling this from a criminal justice perspective, but a collaborative and coordinated response with all professionals and individuals who come into contact with survivors throughout their healing journey. Okay, thank you.
Okay, Mr. Little.
Thank you, Mr. Chairman. Ms. Martinez, one of the novel aspects of Representative Ann Johnson's bill was the addition of criminal culpability for persons who impersonate trusted individuals like mental health services providers, clergy, coaches, and tutors. Did your task force consider any of that in its recommendations or formulating this bill? And do you have an opinion on it?
We did not discuss that, and I do not have an opinion on that. I do know that there is a current prosecutor here who may be able to give you additional feedback in response to that question.
Okay, thank you.
Representative Little, may I also bring to your attention that subsection 3 that you expressed concerns about earlier, the language regarding or unaware that the sexual assault is occurring?
Yes, ma'am.
Is not new language. That language is actually taken and relocated from subsection 5.
I'm sorry, I've got to get back to it. Just 1 second. Okay. Why was it moved from 5 to 3? I want to think about what you said. Okay. Do you know why that language was relocated?
I personally do not, but I have a feeling Representative Howard will be able to address that
She
in her
very well may.
closing.
Are you satisfied that the committee substitute addresses the situation or the problem posed by Ms. Willis's testimony that where the victim's intoxication is not attributable to the conduct of the bad actor?
Yes, sir, in
Okay.
addition to others.
Yes, okay. Thank you so much.
You're welcome.
Thank you for being, we appreciate you being here. The chair calls Dr. Bertha Lavinia Masters.
Versus in the act.
Thank you, Chair Smythe. I am Lavinia Masters. I'm here to represent myself in support of House Bill 3073. Let me say I'm really a nice person. I don't want to come across as a mean person. I just have such passion for the work of survivors of sexual violence because of all of the trauma I've been through, not with just being sexually assaulted at 13, but a college incident where I was drugged and raped by a young man and his brother. And at first I kind of laughed. I say, it's April Fool's. And so I know we're not still talking about consent because I know I didn't give consent on that night. I kind of blocked it out of my mind because unfortunately for the family of this young man and his brother, when they came up for the Grambling Prairie View game, they died in an auto accident. I didn't report the crime because I felt that no one would help me because after my rape at 13, no one was there for me. But I use the analogy, if you leave your homes open and a rapist just decided to come to your neighborhood and he said, I'm going to move in with you, how would you accept that? That's how I look at this. This is like you leaving a door open and we decide we're just going to, a rapist just decide he's going to come in and just reside with you. And you pay all the bills and you feed them and you do all of these things. It's asinine is what it is. And that's what I see in this, where we can't make a decision of what consent is, even if we've been drinking or we've had drugs. My drugs were not intended. I didn't ask for the drugs. I had been drinking, but they put the drugs in my drink. And so I'm here to support that. And I also need you to know that the door was left open with this bill, and we need to close that door today. Consent is like healing after sexual trauma. It's perpetual. It should be ongoing. We have that right to say, I decide to do this, or I decide not to do this with you today. So that's all I have to say about this. I want to keep it nice and simple because, like I said, you'll see me again. You have any questions?
Ms. Jones has a question.
I want to say this, Mr. Masters, it doesn't matter if you can't be angry and upset about what happened to you,
Yes.
and angry and upset about a loophole
Yes.
that makes you prove something.
Yes.
Then when can you be angry and
Yes,
upset?
exactly,
Right?
exactly, exactly.
So, and I think just by the very nature of you coming up here and
Yes.
advocating for people other than
Yes.
yourselves,
Yes, ma'am.
that shows that you're a good person.
Thank you.
So let me
God
start by
bless you.
saying that.
Thank you.
And the last thing I'll say is that as it applies to consent is this. Just because, even if I go get drunk,
Yes.
I'm not getting drunk saying, okay, you get to
Yes.
spread my legs.
Yes.
Right? You don't,
Yes.
That's not what I'm saying.
No.
And we need something to protect people. Sometimes
Yes.
we make mistakes. What
Yes.
if you pretend like you're the parent of, I don't know, a girl, a young
Yes.
girl.
Yes.
Right? Sometimes when you take your first drink,
Yes.
like you don't have a high tolerance.
Yes.
You'll
And
take
that's me.
something, right? And then you
Yes.
drunk. Do you want for somebody to be able to take advantage
No,
of
ma'am.
your child?
Absolutely
So,
not. Absolutely not.
And I just think it makes it clear. I think there are a whole. I went to a bunch of keg parties when I was in
Yes.
high school.
Yes.
Thank God I didn't drink.
Yes.
Right.
Yes.
But I saw
Yes.
the behavior.
Yes.
Right.
Yes.
It was like a heat session.
Yes, it
right?
was.
The people are drinking beer. The guys were trying to figure
Yes.
out who they could get.
Yes. Yes.
And it will cause you, because if this law
Yes.
passes, and then parents can teach
Yes.
their kids, hey,
Yes.
right? If she's drinking, you might not
Yes.
want to do that,
Yes.
right? Because you
Yes.
might end up locked up.
Yes. Yes.
So it's a whole opportunity to make people be held accountable for their actions,
Exactly.
right?
Exactly.
And taking responsibility, it'll make you stop and pause. So
Exactly.
I think you're a good person,
Thank
but I
you.
think if you can't be mad under this circumstance,
Yeah.
then when can you be mad?
Exactly.
And so I appreciate
Exactly.
you.
Thank you. Bless you.
Yes, thank you for being here.
Thank you.
Ms. Bowers has a
Yes,
question.
ma'am.
Thank you, Chairman Smithy. Thank you, Ms. Masters. I do know you to be very kind, and I do know you from the legislation that our former colleague, Representative Victoria Niave Criado, lifted with the Lavinia Masters Act.
Yes,
And
ma'am.
so I want to thank you for doing that for the rape kits that were sitting on the shelves collecting dust, and also just for continuing to use your voice.
Yes,
So,
ma'am.
thank you.
It's necessary.
Mhm.
Thank you.
Yes, it is. Thank you.
Thank you.
And one more, you're not finished. Ms.
Okay.
Rodriguez-Ramos has a question for you.
Thank you, Ms. Masters.
Uh-huh.
You know, I asked the previous witness in terms of what else the state is doing to increase reporting.
Yes,
And I
yes.
appreciate you sharing the story and
Yes.
the other witnesses. It's an absolute act of courage, but I'm always concerned, like, if we have all this legislation,
Yes.
but people are still not reporting,
Yes.
and I understand why, and all of
Yes.
the different facets, but as you explained a little further, I think this is the answer to that, right?
Yes,
Like, I'm like,
yes.
okay, if we do all of these laws, what's it gonna change? But
Yes.
but that's changing the burden from the
Yes.
perpetrator,
Yes.
from the victim to the
perpetrator,
perpetrator is what
yes.
the answer is, I think, and
Yes.
it'll empower and encourage other individuals like you and the
Yes.
others that testified here today. I want to
Yes.
thank you because it's
Thank
an
you.
absolute act of courage to come out here and share your story and for our other witnesses. But I'm hoping this is the answer so that we can increase those
Yes.
numbers of these, because we know these perpetrators are probably doing it again and
They
again.
are.
And
They are.
if we don't speak out, especially young women or women in general, but putting that burden on the perpetrators, I think will
Exactly.
help.
And if I may add, I'm already ashamed that I was violated. I carry that
Right.
shame. And now I was shamed because I drunk a Matilda Bay. Those who are in their 50s may remember that. But I drank a Matilda Bay with someone I trusted and said he liked me and this and that. But I guess because I wasn't giving it up, as they said, they decided to take it. So that's the burden. So now I have the shame. I'm shamed that I drank, that I went out, and hung out and thought I trusted people, could trust people, and it didn't go as I planned, and it was very scary. And I didn't report because, of course, my first rape, nothing happened. It sat on the shelf for 20 years. So now how can I trust my justice system to protect me now? He's going to say, I know her, my word against his. And so this is what happens. And a lot of victims will not report because of those kind of actions. They see what's in the news, what we put out in social media, what's public, and how it looks like Texas will not protect me if I come forward and report. And I think it's important that we continue to advocate and we put out there that we will protect you. We are fighting for you. Please come forward. Please give us that evidence. Please report these incidences. Don't leave everything out high and dry. We are here for you. And that's why I continue to do the work. And I appreciate you all for supporting us and doing the work with us.
Well, and you talked about the shame.
Yes,
This puts
ma'am.
the shame where it should be, is on the perpetrator
Yes,
who
ma'am.
violated,
Yes,
who
ma'am.
then has to prove that
Yes,
there
ma'am.
wasn't any
ma'am.
consent, and that's where the shame
Yes,
should
ma'am,
be.
exactly. And that's when my first perpetrator, when I found him out, I post him everywhere because I'm like, shame on you. Your mama
Yes.
should know what you do in the dark, your grandma, your grandpa, everything, because I carried that weight for far too long, and it wasn't mine, it was yours to bear.
That's
And so
right.
now you own it.
Thank you,
Thank
ma'am.
you.
Appreciate it.
Thank you very much.
Thank you.
Tiffany Larson.
Thank you. My name is Tiffany Larson. I represent the Brazos County District Attorney's Office as well as myself in support of House Bill 3073. Representative Howard couldn't have said it better. Sexual assault is a taking. It's just taking something that you want that the other person isn't willing to give. But when we talk about a taking, in order to take, you have to have a power imbalance. And that is also what we're talking about here. That power imbalance can look different in different cases. It might look like a gun or a knife or strong-arming someone to the ground. But in so many of the cases that I review, it's much simpler than that. It's simply a vulnerability. One person is in control and the other person is not. All of us know what it looks like when someone is impaired. We see it all of the time, and we're very, very able to recognize when someone isn't okay. They're no longer really in control of their body, and they don't really know what's going on. Perpetrators can see it too. They do see it, and they take advantage of it. Very importantly, as a prosecutor, I really want y'all to understand we are not trying to criminalize two consenting adults who get intoxicated and have sex. We are looking at that power imbalance, and we are looking for a person who is taking advantage of someone who is not in their right mind while they very much still have control of their own. If somebody knows what they're doing and the other person does not, and they sexually assault them, that needs to be a crime that is very clear. And right now it is anything but. As we mentioned earlier, Representative Little, the unaware sexual assault is occurring. We've had that on the books for many years, but no one knows what it means. And that is a huge problem when you're in a courtroom trying to explain it to a jury. And we want to be able to explain this very clearly to a jury. We do want to increase reporting, Representative Ramos. It's so important that our survivors know that when they come forward about a case like this, I have some means to hold the perpetrator accountable. I won't be able to file a charge every time. We probably won't be able to file a charge in many of these cases. But this will give me a fighting chance to hold someone accountable when the evidence supports that obvious power imbalance and clearly what is a sexual assault. I just also want to briefly answer your question about impersonation, if I may answer that question, Representative Little, because I am familiar, and I may have even been the one to mention it to Representative Johnson in a courtroom because I did practice in Harris County for a number of years. We had an individual who pretended to be a doctor. He put on a lab coat and put out an advertisement asking young women to come and apply for an assistant position. Now, as certainly possibly gullible or naive as it may have been for these young women to believe that he was a doctor and to believe they were applying for a real position, part of his application process was that they each had to come into a restroom and give a sample, and he penetrated them. Now, he will tell you that he had their consent, but it was anything but consent because it was based on a lie, it was based on fraud, and he was not a doctor, he was a scam artist. I don't have a statute right now that protects the individuals who were victimized in that case, and it was a lot of legal gymnastics trying to figure out how to charge it appropriately. And so the idea behind that particular statute would be to take the legal gymnastics out of it. If you pretend to be a medical professional or you pretend to be administering medical care and you are not, and you achieve that consent, but you're now penetrating someone based on that fraud and deception, it should be a crime in Texas. And unfortunately, I have other examples from my time in Harris County. So it's not really a one-off, and it's something that needs to be addressed. And I'm very excited to hear that it might be happening this particular session.
Thank you, Ms. Larson.
Thank
Any
you, sir.
questions, members? Okay, Mr. Wu.
Thanks so much for your testimony, and I just want to touch up on, like what you brought up earlier, saying that we're not going after people who are both clearly intoxicated and both of them didn't know what's going on. There's nothing in this legislation that tells prosecutors to turn off their brains, right?
That's exactly correct. Thank you so much, Representative Wu. And I know that you are a former prosecutor from Harris County. And I think that that is very important. I've been kind of making some jokes about not ever really being accused of overcharging this crime. No one is ever going to be reporting that we are doing this too much. If anything, it's the opposite. We are underreporting, underutilizing our investigation tools, and underutilizing our prosecutorial abilities in prosecuting this crime. But it's mostly because we have cases where there's good evidence and we don't have the right statute for it. We will always use our discretion, and we always have to make a good decision about whether or not we should be prosecuting any particular crime. Because as we all know, that still has to carry in a courtroom, and there's a heavy burden on the state, and we don't want to, and all of us in prosecution feel the same way. We would never want to put a survivor through a secondary trauma of a trial if we didn't think we had the evidence to support the charge. So we take that very seriously. But we're definitely conceiving, and I've worked very closely on the SASTIF with Nicole and the rest of the team to find a way to build into the statute that we currently have an ability to prosecute good cases that we believe in and we support and we have the evidence to support, but we just don't have the right language to do it.
Thank you very much.
Thank you, sir.
Thank you.
Okay, thank you. Okay, Mr.
Yes,
Cook.
sir.
Just going back to the language that Representative Little was talking about earlier, B6, do you have it in front of you?
Yes, sir.
So I just want to clarify, so as far as the situation where the rapist is claiming that he was too drunk to have known or whatever, is this the best language we can possibly have that the actor knows or reasonably should know? Is that as close as we can get to addressing that situation?
Yes, sir, I believe that it is. In the criminal cases, we of course have to prove up that important mens rea component. And so we do still have to show that the perpetrator knows that the other person is not consenting. That's always been true of our statute. It is hard for us to do that in certain cases where two people are intoxicated, but again, we're looking for that power imbalance. Generally speaking, in these cases, the other person really should have known, or maybe even we can prove did know, that the other person was too impaired to consent. But right now, what we have is just that unconscious or physically unable to resist or unaware that sexual assault is occurring. And I'm sorry to say that I have heard defense attorneys tell me that if she was unconscious, then maybe she just doesn't remember consenting. We've got to take that out of the equation. I shouldn't be having to explain to a jury the nuance of unconscious and whether or not we're going to take that literally or not. Representative Jones talked about jury charges earlier. When I have to write a jury charge with the current language, it is very, very difficult.
I know we need to move on, but
yes, sir.
But mine's more about going back to the mens rea.
Yes, sir.
I want to focus on reasonably should know. Is that sufficient? Is that the best language we can come up with? It just seems.
Yes,
it
sir.
Still seems,
I can appreciate why you're grappling with it. We did the same. The reasonable person standard is certainly something that we're very familiar with in criminal practice, and that's what we're trying to get to the heart of here. From a reasonable person's perspective, should they have understood that the other person was not consenting? And in this instance, I think this language will help us do that.
Thank you.
Thank you, sir.
Thank you for being here. We
Thank you.
appreciate it. Members, is there anyone else here to testify for, against, or on House Bill 3073? If not, Ms. Howard, do you want to close?
Thank you, Mr. Chairman. And I just want to, Representative Little, just say that from my understanding now, having talked to others, is that that language that is, or unaware that the sexual assault is occurring, already existed. It was in current, and it just got moved for clarification purposes rather than just being a standalone section. That's all there was to it. There's no more meaning to it or significance than that, is my understanding. Just wanted to make sure we pointed that out. Yeah, sure. Well, thank y'all so much. I think we recognize that we need to do a better job of getting people to report. This is one of the ways we can make that happen if people have trust that the system is actually going to move forward with the prosecution. And that's something that we obviously haven't seen happening. And prosecutors have told us this is one of the ways that we could strengthen the language and give them the tools they need. So I think it's time we started placing the burden of proof on the perpetrator to prove that they had consent in the first place rather than continuing to shame the survivor. And I hope for your favorable consideration and
Well, we appreciate you bringing the bill, and also, while we got everybody here, appreciate the task force members for the
Yes.
time that you've put in, and for
Absolutely.
some, a lot of you, it's been hard. Been hard to actually do the work, and I know we understand that. We appreciate you being willing to give your time and effort to do this, because it does make a difference. I think it results in a better work product that we can work with.
Thank you,
here.
Chairman. I think it's evident that these people have put in lots of time, lots of thought in this, and they are the experts in the area, so I'm hoping we can listen to them.
Yeah, it makes our job a lot easier.
Absolutely.
I know that. So it makes us look better by
Absolutely.
passing better bills, so we appreciate it.
agree.
Thank you very much.
Thank you, Mr. Chairman. I close.
Oh, just hold on.
Oh, just real quick.
Learn how to dance.
You got to be quicker.
I know, apparently.
Representative Howard, thank you for this bill. It's a little bit easier to understand. The substitute is even, it's better than your original bill even. Even I can understand it. I would just encourage you, and this is your bill, obviously, and you're very experienced at this, far more experienced than I am, but I think Representative Johnson's inclusion of those impersonation provisions that we were discussing earlier is actually germane to your bill and really helpful. So I would just encourage you to consider adding those into your bill if you have an opportunity, because your bill obviously has a very good chance of being heard and passing.
Well, I appreciate that, and it was not in the recommendations from the SASTF, which is what this came from, so that came separately, as you heard from Ms. Larson. So
Yes, ma'am.
Thank you for that. I appreciate it.
Okay. Thank you very much for being here.
Thank
And
you.
If there's no objection, members, the chair will withdraw the substitute and leave House Bill 3073 pending for now. And Mr. Capriglione, you want to, the chair would lay out House Bill 2151 and recognize Representative Capriglione.
Great. Thank you, Mr. Chairman, members. Thank you for the opportunity to address the committee today. I'm here to speak to you about House Bill 2151, which strengthens Texas's sex offender registration laws by addressing gaps related to the offense of indecent assault. Under current Texas law, individuals convicted of indecent assault under Section 22.012 of the Penal Code are not required to register as sex offenders. This is despite the fact that indecent assault involves non-consensual, inappropriate touching that can result in serious and lasting harm to victims. Texas law rightly requires sex offender registration to protect the public and inform communities. But the omission of indecent assault, particularly in cases involving repeat or aggravated conduct, undermines those protections. House Bill 2151 addresses this issue by requiring registration for individuals who commit multiple or egregious instances of indecent assault. This legislation ensures that individuals who demonstrate a pattern of predatory behavior are identified and monitored, helping to prevent future harm and supporting victims. It serves as a deterrent, underscores the seriousness of the offense, and provides law enforcement with the necessary tools to monitor and manage offenders effectively. There's no place in Texas for those who do harm to our families and children. House Bill 2151 is a necessary step to protect victims, deter repeat offenders, and make our state safer for everyone. Happy to answer any questions.
Any questions? Okay. Thank you. We've got a
Okay,
witness.
I reserve the right to close.
This is just on this is just on the enhanced provision, not on the base Class A misdemeanor.
No, this is if on the, both. If on the Class A provision, you're found guilty and then you're found guilty again.
Yes,
then-
you're talking about the enhancement, the subsequent, because this used to be a Class C misdemeanor. We created a Class A out of it, and then I
Yes.
think Representative Julie Johnson created
This
an
is on the
enhancement
Class A,
provision.
yes.
So this is on the enhancement, the successive
The successive
conviction?
of the, yes,
Got it.
two or more of the Class A's,
Got it.
exactly.
Okay, just making sure.
Thanks. Anything else? Okay, and we'll
I reserve the
certainly
right
give
to
you the
close.
right to close. And the chair would call Lauren Lawrence. Go ahead.
Good afternoon, Chairman Smithy, members. My name is Lauren Lawrence. I am here on behalf of Phil Sorrells, Tarrant County District Attorney. We are in favor of House Bill 2151. I mainly want to just be here as a resource to answer any questions that you have, but having been here this afternoon and listening to the broader conversation that we've been having about sexual assault and how difficult that offense can be to charge, I wanted to inform the committee that what we are seeing in our office is that in an instance where we do have a sexual assault that it is difficult to charge, one that we may not be able to charge as a sexual assault, or one that is charged as a sexual assault that for whatever reason we do not believe that we are going to be able to prove at trial, many times those cases are getting pled to indecent assault. And so what this legislature created as something to address groping has really become an avenue for prosecutors to get some sort of plea, some sort of an accountability on really difficult cases that we otherwise can't prove, which is just another reason why, if somebody is repeating this offense multiple times, we should be able to have them on a registry. So I'm happy to answer any questions.
Right. Any questions, members? Okay. Thank you for being.
Are you able, if you
Ms.
could
Moody.
just, and I don't know if anybody else is interested, but I'd be interested in if you're able to parse it out from Tarrant County, those instances where you are utilizing it as a plea down, or I'd be interested actually just as the author of the base offense itself, going back a couple sessions, how is it being utilized as a base level offense for the actual groping conduct? It's hard to track the data prior to the enactment of the law because it was done in Class C world, and that information isn't collected. I guess we can get it from OCA, but it'd be interesting to know how y'all are utilizing it as the base level offense too. And we don't have to go into it now, but if you're able to supply that information, that'd be great.
I can give you a brief answer to that. I went through and ran the offense through our internal system. We currently have 40 pending indecent assault cases in our misdemeanor section, and they range everywhere from a groping incident in the middle of an otherwise verbal family violence altercation to what we are also seeing it being used as very frequently, though, is in instances of massage parlors where individuals who are performing a massage are inappropriately touching the person that they're giving that massage to in a way that was not consented to. So that I would tell you is one of the ways that it is being used very frequently in our office.
No, that's great information. It's always interesting. It's always interesting to see how those things then get worked out in the real world. And so I appreciate that information. Thank you.
Okay. Thank you very much for being here. Anyone else here to testify for, against, or on House Bill 2151? If not, Mr. Chair recognizes Mr. Capriglione to close.
Thank you. Speaker Moody, thank you for your work on this legislation. Mr. Chairman, members, I'm happy to answer any questions. If not, thank you for considering House Bill 2151.
Okay,
I
thank
close.
you. Any questions, members? Okay, thank you for
I close
being
again.
here.
Thank
And if there's no objection,
There you go.
if there's no objection, the chair will leave House Bill 2151 pending for now. Ms. Hull, are you ready? Okay, the chair lays out House Bill. You want to do 1686 first? Okay. The chair lays out House Bill 2582 and recognizes Representative Hull.
Thank you, Mr. Chair and members, for allowing me to lay out House Bill 2582. During the interim, my office was contacted by a crime victims advocate who was assisting a victim with finding out information about the offender's parole in order to plan for her safety. TDCJ has stated that under current law, the Victim's Bill of Rights entitles a victim to know when an offender is eligible for or granted parole, but no other information. Despite the fact that the offender is granted conditional release into the community and still monitored by TDCJ, currently information about their parole is prohibited from being released under the Open Records Act, and crime victims do not receive any special privileged information. My bill would not open this up. My bill would not open this information up to public disclosure through open records, but make it available to victims. It would require TDCJ to notify a victim or family member of a victim to be notified of the county the offender was paroled to, and conditions that could impact a victim's ability to safety plan, such as orders prohibiting the parolee from going near her home or work, a condition to complete a battering intervention and prevention program, and if the offender is subsequently charged with the crime, has a warrant issued for a revocation hearing, or has their parole revoked. Since I began working on this, I have heard from other survivors of crime with similar situations where they feel this information would have helped them plan for their physical safety and peace of mind. I am working on a substitute to allow for a victim's advocate to request this information on their behalf. It will also clarify, at TDCJ's suggestion, that the notification of a subsequent offense is only while the parolee remains on parole, as TDCJ would not have information about any arrest after they have been released from parole. I know there are some witnesses here to speak about how important this information is for survivors of crime. I'm happy to answer any questions and reserve the right to
And
close.
I know in other cases, you can get the information, but not, in this case, they haven't been able to get the
Correct.
the information. So any questions, members? Okay.
I've got some
Okay,
questions.
Mr. Little?
Thank you, Representative Hall. I've got some questions, and my concerns deal with primarily Section 7 of your bill. This is related to discovery in criminal defense cases, and it provides for the court allowing for discovery of a communication or record that is otherwise confidential or privileged by law. And are you with me?
We're on 2582.
I'm sorry, I'm on the wrong one. I'm on the wrong, your bill, excuse me.
Yes, it's okay.
I'm sorry.
No,
I'll
it's
come back
okay.
to
Yeah, I
it.
have two.
I'm sorry, my apologies. I'll come back to it.
No problem.
Okay, anything else, members? Okay, if not, we'll allow you to close and.
Yes. Okay, oh, and I wanted to
Okay,
clarify.
okay.
They can get information on bond or bail, but not on parole.
Right.
So, yeah. Okay.
Okay.
Thank you.
Chair calls Andy Kahn.
Good afternoon. I'm Andy Kahn, Director of Victim Services for Crime Stoppers of Houston, and I'm here in support of House Bill 2582. And I was the one that Representative Hull was referring to when last year I made a request on behalf of a victim's family who, for obvious reasons, wanted to know what the offender's rules and conditions were that
Mr.
was
Kahn,
being
I've
released.
got to stop you real quick and clarify you're here on behalf of Crime Stoppers Houston and yourself.
I am.
And you're for the bill, right?
Yes.
Okay.
I'm here on behalf of Crime Stoppers of Houston, and I'm here supporting House Bill 2582.
And also
And
yourself.
myself.
I'm just trying to keep the record clear.
That's
Okay,
all right. And
good.
anyone else that wants to be with me, they can also support it as well. So, all right, so where were we? So, when I was contacted by a victim who obviously wanted to know what the offender's rules and conditions were since they were on parole. It's not a bizarre question. And I said, sure, let me go get it for you. And I called and TDCJ and was told that no, I was not entitled to that information. All I said was, you mean you can't tell me I can't get a copy of the offender's parole certificate? No. Okay, fine. I'll get a bill filed and we'll get it taken care of that way. Think about this in retrospect. If a defendant is on bail, I have readily accessible all conditions of their bail. That's accessible, that's transparent, that's public. If an offender is on probation, I can get access to their rules and conditions on probation. But for some quirky reason, you can't get access to someone who's on parole. That needs to change. The reality is an offender on parole is still by definition under state custody. The only difference is instead of serving their time behind bars, they're doing the remainder of their sentence in the community. And for victims, it's vitally important if they choose to want to know what the rules and conditions are. There is absolutely no downside in allowing a victim a copy of a parole certificate or an advocate that's representing a victim or a victim's family. I serve on the board of Parents of Murdered Children and Surviving Family Members of Homicide, Texas EquiSearch, and Texas Crime Victims United, and I can unequivocally tell you the organizations that I serve on wholeheartedly support this. And if Representative Moody was still here a couple weeks ago, he spoke to another victim by the name of Paul Castro when he was a little bit surprised that Mr. Castro had difficulty accessing information on pretrial releases, and he met with them, and he found out Mr. Castro was right. The same thing is happening right here. So I would urge you to go ahead and pass this out and give victims the peace of mind that they so deserve by simply allowing them to know what the rules and conditions are. Thank you.
Thank you, Mr. Khan. Any questions? Okay. Yes, Ms. Rodriguez-Ramos.
Thank you, sir. How do the victims know now when somebody's going to have a parole hearing?
They register with TDCJ's Victim Services, and then they get notified that the offender is up for parole. And they have an opportunity to participate in several different ways. They can request an in-person hearing, they can submit letters. So there's a lot of ways that they can have access, that they can actually help or assist in determining whether that person gets released or not.
Okay, but they're not giving any information after the fact if their person is, if their parole was approved or not?
Yes,
in
they
terms
are.
of the
They're
county?
advised whether an individual's parole is either approved or denied and when that next hearing is, assuming that they are denied.
And then when they, let's say, assuming they're approved, what type of information is the victim, do the victims typically receive in that case, other than?
They're told they're
requesting?
approved.
Okay.
So that's why we're here today, because some of them, and I have no idea how many want, I just don't know, but I think that they should be able to decide for themselves whether they want to have that information or not. We shouldn't have that shut down. And in this day and age, there is no reason why that information should be considered confidential and classified as public information. And I think Representative Hull's bill, keeps it to where it's victims or victim advocates. But I'll just tell you from a personal perspective, it should be open to everybody, but I get it, why we're doing this as well. Just like someone's on bail, anybody can have access to any defendant's bail conditions.
Mm-hmm.
Same thing on probation. There shouldn't be any difference when an offender is on parole.
Thank you, sir.
You bet.
Appreciate it.
Thank you. Anything else, members? Not. Thank you for being
You
here,
bet.
Mr.
Thank you.
Khan. We appreciate it. We also have Dr. Bertha Lavinia Masters.
Good afternoon again. Chairman Committee Smiley, everyone on the committee. I am Lavinia Masters. I'm representing myself, and I support House Bill 2582. First, I would like to honestly thank Representative Hull for this bill, because when they reached out to me, I had no idea they were doing this. It hit home. I don't know if many of you know my story, but last year, I got a letter that my perpetrator, because of DNA, I know who my perpetrator is, was coming up for parole. He is a known serial rapist. So they invited us to come down to Palestine to do an interview. And we did the interview, and this is exactly what happened. I wanted to know more about my perpetrator. How, where will he be? What county will he be in? I just wanted information about him. Can I participate in his outline of training? Because of course he served 10 years prior for other rapes. He got out, same MO. This time he raped an elderly woman in her home at Knife Point. And I felt that I should have access to this. For one, my understanding or what I see, these perpetrators, they have access to the internet. They have phones in prison. They get square meals every day. They have so many privileges behind bars, and my understanding is on my dollars because I'm a taxpayer, and I'm paying for my rapist to enjoy his life behind bars, but I can't have access to anything about him once he's released. But he can go to the same internet, and he can look up my name, he can find me, he can do a search if he wanted to and see what I'm doing, where I'm located. And this concerns me that I don't have that same access. So we did do a news, Tanya Iser with Channel 8, we did a whole story about it because it's very concerning to know that victims did not have this information. I cannot participate or know what my perpetrator is going to do next, what city he's going to move in, anything. It's like it's a big secret. His rights, his constitutional rights is what they said to me. And I gave them a belly laugh right there in the interview, and I still give that belly laugh today because it doesn't make sense to me to give them so many rights, so much protection, especially if I'm not one to have a vendetta and try to take any action against him. I just want to make sure he's rehabilitated, that this is a public safety issue for me. It's not just about me, it's about others. Because if he's done it once, he was released after 10 years, I'm pretty sure he'll do it again. And even the board told me at that time that he was a serial rapist, and they believe there are other victims that have not come forward from him. So it only makes sense for us to support 2582, and we give the victims that empowerment of knowing we're already downtrodden, broken, despondent, and we need our power back. And part of that is allowing us to have some sort of control of that monster that took away our control when they violated us. Thank you.
Thank you again.
You're welcome.
Ms. Masters, Dr. Masters, Ms. Jones has a question.
Okay.
Again, I'm going to thank you for coming up here because I think you help people understand, like in practical matter, like what happens every day. 'Cause
Yes,
a lot of
ma'am.
us don't.
Yes, ma'am.
And I was thinking about this. Although it wasn't a sexual assault, I was threatened. Somebody said they were going to kill me, and they actually found him like a half a mile away from my mom's house because he had my next of kin's contact information. 'Cause somebody told me, you need to be careful, and I was able to get a red slip, which is in Houston, is when the police drive by my house and my next of kin's house just to make sure that we're okay.
Yes.
Jump to the end of the story. He ended up getting sentenced to 18 years in TDC.
Yeah.
And it's crazy. So when he was locked up, because you have to serve half your time before you're eligible for parole in Texas with a 3G offense. So I felt safe for the first 9 years. And then at some point when it was time for him to come up for parole, I wanted to participate. And he actually came up earlier than I thought. And by the time I found out where he was, he literally had paroled out to Houston.
Oh, wow.
And I had no clue
Yeah.
that he paroled out to Houston. So I know what it's like personally to have someone do whatever it is they do to you and just not know.
Yeah.
So I'm again, I'm going to thank you for.
Thank you.
But it was the Dickens trying to get TDCJ to get me the
Yeah.
information.
Yeah.
And the truth is, I called somebody who I knew was elected at the time.
Yeah.
Right,
Yeah.
to get the information because I couldn't get it from TDCJ, and unfortunately, for most people, they don't have access. They don't have access to a senator.
Right, exactly.
To give them that
Exactly.
information.
Exactly.
So thank you.
And I lived in fear for all those years. And now I have to revisit this over 40-something years later because he's coming up for parole. And why do I have to revisit that fear, be re-traumatized? Because I can't have access. Give me that control. Give me some sort of power out of the deal is how I feel.
Or even to just protect yourself.
Yes, ma'am. Yes, ma'am.
Yes.
Well,
My
thank
husband
you.
said I'm a good shot, though. He taught me how to shoot. Thank
Once
you.
again, thanks for being here. And so we have members, we have Tim McDonald with the Board of Pardons and Paroles, I assume is a resource witness.
Yes, good afternoon, Chair Smithy and members of the committee. My name is Tim McDonald. I am the Chief of Staff with the Board of Pardons and Paroles. I'm neutral on the bill, and I'm here as a resource if there are any questions.
Any questions, members? Ms. Rodriguez-Ramos has a question.
How do you all make sure that information is updated for individuals or victims that you want to notify of any upcoming parole hearings for any offenders?
So the victims are required to register with the Texas Department of Criminal Justice Victim Services Department, and they provide the notifications to the victims when somebody comes into parole review for the opportunity to participate in that process. And if a victim wants to speak with a board member or parole commissioner prior to a decision being rendered, our staff will reach out to them to set up that appointment. It can be done by telephone, by video conference, Zoom, or they can come in person.
So the victims register so that you all are alerted when this individual comes up, they'll be given that information.
Yes, the registered victims will be provided that information that somebody's coming up for parole. Also, they can register to be notified if an offender is released, if there is a warrant issued for their arrest too.
But not necessarily where they will be released?
It's my understanding just prior to somebody being released on parole, a registered victim is provided the county and the date on which that person will release to.
Okay, all right, thank you.
You're welcome.
Any other questions? Okay, thank you for being here. Ms.
Thank you.
McDowell. Appreciate it. Is there anyone else here to testify for, against, or on House Bill 2582? If not, Representative Hall, you want to close?
Unless there's any questions from members, I will close.
Any questions? Okay. Ms.
So,
Jones.
so I've got a question. I represented somebody before who had a stalker, and the person wanted to commit physical violence and like rape them. But this person had a bunch of charges thrown on him. I mean, like couldn't stay away from my client's home. The DA's office in that case chose to have some charge, like accept some charges and then not accept other charges, or charge the person with a lower level. And because they ended up dismissing the less serious charges, like the misdemeanors, and went on more serious things like where the person actually assaulted law enforcement when he was locked up, right? And I had the hardest time getting the DA, can you please notify my clients when this person has court next time, right? You decided to go on the case you thought was strong, the cases you thought were stronger, and you literally left my victim out there because you think it's easier to make the other cases. My question is, does this bill cover that?
No, this is just parole.
Okay.
Just strictly parole.
Okay.
Okay.
Yeah.
Okay. Any other questions, members? Okay. Thank you, Ms. Hall.
Thank you.
And so, members, if there's no objection, the chair will leave House Bill 2582 pending. Ms. Hall, you have one more, but can I do Mr. Anchi? He's just got one witness, and so, and you've got several. So let me. The chair will lay out House Bill 2697 and recognize Representative Anchia.
Thank you, Chairwoman Hull, for that accommodation. Thank you, Chairman Smithy, Vice Chair Wu, members of the committee, including my friends and colleagues from North Texas. I wanted to talk to you about an issue. It won't take particularly long because it's something that feels very, very straightforward. And to highlight the issue, what I want to share is a fact pattern that I think many of you who are in criminal justice might find familiar. Currently, when a defendant has committed a serious offense and they get released on a surety bond, that person is required to follow up on certain court-ordered appointments, including periodically appearing, doing drug testing, reporting to the surety or bail bondsman, and to the court. However, if the defendant commits a new offense or violates mandated conditions, the bail bondsman, who is oftentimes the first person to find out about that because their money is at risk, they may file an affidavit with the court and the defense attorney recommending that the criminal defendant be brought back into custody. And now, even though the court is notified, the defense attorney is not required to bring this issue to the awareness of either the judge or, more importantly, in this case, the prosecutor representing the state. And so when the prosecutor doesn't know, there are impacts. And so this bill is fairly straightforward. It says you got to let the prosecutor know so that they can file a motion, because if they don't know, they don't have the ability to file the motion, and they're unable to move the court to order the defendant back into custody. It's simply notice. And you'd think, Representative Jones, that with all the bonds that we've had over the decades and decades and decades, that this issue would have been covered, but it's not. And it's having some real adverse effects in places like Dallas County, of course, around the state, but this was brought to me from our friends at the Dallas County DA's office. So I'd like for you to listen to them, listen to a couple of fact patterns that this failure to notify, or this failure to require notification has had some real-world consequences. And I asked this committee if you can help me solve this issue. I'd be incredibly grateful because it has a negative impact on the administration of justice, not only in Dallas County, but throughout the state. Chair Smithy, I know that members do not have a right to close, so I will beseech you and the members of this committee the opportunity to close.
We will not deny you that privilege.
Thank you, thank you.
Any questions for Ms. Nchia? Ms. Jones?
So you're telling me that in Dallas County, because the bail bondsmen in Harris County, they run to the court to surrender the bond, and the state knows. I can't. And why does the state not know they picked up? I mean, the state generally knows that they picked up a case. We get bond violation reports, or in general, it'll be like they picked up a new case. So I'm trying to understand how you're saying it's working or not working in Dallas County, because I've never seen that.
So in the bond, the bondsman, the surety, they're usually the first one to go and say, hey, we want to have this person go back into custody, or they want a revocation. There is a notification to the court, to the defense attorney, but not to the state. I know. Seems weird, doesn't it?
In fact, I get told, you better come to court. And sometimes it's less than 24 hours notice because the bonding company wants to surrender the bond.
Right. And
But
are
we
you
literally-
defense counsel?
Yeah.
Yeah.
But what I'm
But
saying
what
is
we're
the
talking
state-
about is notifying the prosecution, in this case, the state.
So you're saying that when the surety wants to surrender their bond, the surety has to notify the state that they want to surrender the bond. Is that what you're saying?
Precisely.
You know what? I'm going to come to your office and talk to you about it, because I just don't know how that works. But I'll come. I'm certain we can work it out.
I appreciate the questions, and thankfully, we have people from the Dallas County District Attorney's Office here to testify, and they will be able to give you the best answer.
Okay.
Thank you, Representative.
Yes, okay.
Thank
We
you,
will
Mr.
allow
Chairman.
you to close, and then...
Question.
Oh, I'm sorry, if you could come back
I
up. Mr.
apologize,
Blunt.
Representative Louderback. I didn't mean to step away.
Representative, thanks for bringing this up, but let me make sure I understand, because now when you surrender when a bondsman comes in and says, I'm going to get off of a bond, is this what you're referring to? Because they're required to bring their defendant with them at that time. Now, if the person absconds and they're gone, then what are you asking to do, that the prosecution be notified?
Yes.
Okay, you're saying they're not notified at all?
Currently, when the bondsman, the surety, goes to get the bond, there is no affirmative requirement to notify the prosecution. Usually the defense counsel knows, oftentimes the court knows, sometimes the judge knows, oftentimes the prosecution doesn't know. And we have people from Dallas County here today who'll talk about how that's affecting where the rubber meets the road.
Okay, thank you.
Thank you, Representative.
Quick question.
Okay, yeah, Mr. Cook has a question.
Thank you,
Is the
Chairman
purpose
Cook.
of this bill to make sure that a person that's on bond stays on bond, or has it forfeited and is incarcerated?
That's exactly right.
Okay, thank you.
Thank you.
Okay, thank you. So the chair will call Jason Hermes.
I've never seen that happen. Like, not
Good afternoon, Mr. Chairman, committee members. My name is Jason Hermes. I'm here on behalf of John Crusoe, the District Attorney of Dallas County, Texas. I am a prosecutor, been a prosecutor for 23 years, and testifying in support of House Bill 2697. I can certainly give any of the committee members any number of examples, but yes, in fact, it does happen in Dallas County, and so I have to presume it happens throughout the state. The law does not require a bondsman to notify me or my office when he attempts to surrender his principal, and usually the basis for the surrender is because his client, the defendant, has absconded. And this happened to me personally in two very important cases that I was working on at the end of last year. One of them was a defendant who had made bond on about 5 or 10 first-degree felony cases, including aggravated robbery. And I got contacted several months later by a chief of police because they were doing a capital murder investigation on this defendant. And it was only because of me being made aware of that new investigation that I looked up into the filings and found a filing from the bondsman about 3 months prior trying to get off the bond. The bondsman did not know where the defendant was. So the defendant was just basically running around free, when had I known 3 months ago, I could have helped the court and the bondsman by sending out my investigators and getting police departments and fugitive units and task force out there to find him before he committed numerous other offenses. Now, this happened to me twice. There was a second instance where the defendant was also out for shooting at a car that was occupied by people, and he stopped reporting. The bondsman filed what we call the ATGOB, the attempt to surrender the surety, or the principal by the surety, and it just remained just blindly existing, or just existing anonymously or without anybody's notice in the court's filing system. I went to the judge, asked the judge, are you going to act on this ATGOB? And the court was, I expect a party to move this court. So if you want this person to be apprehended and brought into custody, you need to move me to do so. And again, it was only because in that case that I had been made aware by a chief of police that this person was out in the public, not showing up for his bondsman, not showing up for court. The police department said, this is an active and current public safety risk. Is there something you can do about it? Again, I just happened to look up in the public filings. I saw an ATGOB had been filed a couple of months previously. I took it to the judge. We moved the judge to act. The judge held the bond insufficient, and a warrant was issued. We had the person in custody that same day. So I do ask you, I know it's hard. I've never seen in 24 years where the state of Texas, as the primary party in charge of public safety, is explicitly and expressly not given notice when a bondsman believes that his principal is a flight risk. So I ask that we change that.
Okay. Any questions? Ms. Jones?
So whenever anything is filed with the court, I get an e-file notice. Now, whether I go look and see what the e-file notice is I check, but sometimes they don't. You're not getting, y'all don't have e-file in Dallas County?
We do.
And you're saying the e-file system isn't telling you there's been a notice filed in this court for every pleading, and the sureties, at least in Harris, have to tell us they want to surrender the bond. It just seems weird to me.
So I had dinner last night with a colleague of mine, a district attorney, who told me this as well. In his county, the bondsmen are very proactive, and they want to tell the district attorney. They want the help to get their financial obligations absolved by a court. In Dallas County, and I have to presume in other large counties, when the bondsman goes and files the paperwork, sometimes that is e-filed, sometimes it's actually just hand-delivered to the clerk of the court. But yes, ma'am, I'm telling you, I, as the attorney for the state, am not aware. I was not aware of those ATGOBs. My office is regularly not aware of them. We would like, what this bill does, will require that the bondsman notify, in addition to the requirement that he has to notify the defense attorney, and the requirement that they file the ATGOB with the court, would have to notify the state's attorney that they're going to do that. And that way I can look at the basis, and I can say, look, if public safety says that I need to act as well, I would like to get this in front of the judge today rather than Monday or weeks from now.
So at least in my practice, it's not actually the bail bonding company that's notifying me of anything, right? I get told by the court, you better get down here. Your client has a bond violation. The bonding company wants to get off of the bond. So I'm not aware where they have to do it. I mean, I just know about it because I get a notice from e-file.
Yes, ma'am.
Or a lot of times I get a call from the coordinator saying, hey, we have your client on docket tomorrow. I need for you to reach your client, get your client down here so that we can deal with these. So
it sounds to me like you've got a very good, your court is very on top of things. Article 1719 requires by law the bondsman to notify you.
Well, they never do that.
Well, they should. They should. And I would like them to notify me too, ma'am.
Okay.
Okay. Any other questions, members? Okay, thank you for being here, Mr. Holmes.
Thank you.
Anyone else here to testify for or against or on House Bill 2697? If not, Chair recognizes Representative Chia to close.
Thank you, Mr. Chairman and members. Again, I'd like to thank Chairwoman Hull for the accommodation of allowing me to go. If there are no further questions, I'll just simply close.
Okay. Any other questions? If not, if there's no objection, the chair will leave House Bill 2697 pending for now.
Thank you.
We'll try to get it out. Now, Ms. Hull, you ready? The chair lays out House Bill 1686 and recognizes Representative Hull.
Thank you, Mr. Chairman and members, for letting me lay out House Bill 1686. And thank you for the work this committee has done thus far to protect sexual assault survivors. This bill respects and protects the dignity and agency of sexual assault survivors by providing additional privacy protections based on feedback from survivors when they are going through the criminal justice process. One of the primary barriers to a survivor of sexual assault seeking justice is fear over the loss of privacy. Current Texas court practices can further traumatize survivors by sharing the darkest, most personal details of the crime committed against them with potentially to the entire world. Survivors have already borne the burden of the most egregious invasion of personal autonomy to then be forced into the public sphere where their private and personal information is shared is often too much for a victim of sexual violence to bear. This bill addresses these concerning court practices to ensure that sensitive personal details of sexual crimes are kept private and survivors are not re-traumatized or shamed in the process of seeking justice. Specifically, this bill will place necessary safeguards on the live streaming of cases that involve sex crimes. In the aftermath of COVID, many courts turned to providing online access to their courtrooms. Unfortunately, this practice had the unintended consequence of trampling on the victim's rights of privacy and dignity when they are testifying about such private matters as a sexual assault. My bill would require a court to first gain consent from the district attorney, the victim, and the defendant before live streaming a case that involves a sex crime. Additionally, the bill will allow victims to request a pseudonym during the prosecution phase of their case. Current law requires victims to immediately request a pseudonym during their initial interactions with law enforcement. This requirement is impractical as in the immediate aftermath of a sexual assault, many victims are focused on their physical and emotional well-being, not the prosecution of their attacker. Allowing victims to request a pseudonym beyond the initial interaction with law enforcement will encourage their continued participation in the criminal justice process. This substitute also requires law enforcement to notify the victims of their right to use a pseudonym. And finally, this bill will create important evidentiary safeguards for victims of sex crimes. Texas law provides that defendants are entitled to all the evidence that is available to the prosecution. This bill would simply safeguard certain types of evidence of a sensitive nature by requiring that they be placed under a protective order. Defense counsel would be prohibited from the copying or dissemination of the evidence and must return the evidence back to the state or destroy it at the disposition of the case. This language is the main change from the introduced version and reflects additional feedback after conversations with the legal community and strikes that balance to ensure against unintended consequences in the implementation of the bill and to protect the integrity of the Michael Morton Act. And I want to thank the Criminal Defense Attorney Association for working with us on the substitute language. The decision of how and with whom to share one's story should be the sole decision of the survivor, because making a report to law enforcement is so daunting, it results in the underreporting of sexual assaults and similar crimes. By addressing practices that may discourage survivors from seeking justice, we can encourage reporting so that our justice system can work the way it's intended. And I believe there are some survivors here today to testify.
And I'm sorry, I should neglect, I believe we have a substitute.
Yes.
On the bill. So at
Yes.
this time, Mr. Cook will lay out the committee substitute for the committee to consider. And so we will, anyone particularly to call as the first witness or? Oh, Ms. Jones has a question for you first.
TCDLA signed off on all of this? Texas Criminal Defense Lawyers Association?
We have been working with them, so if they're here, they can come and speak to that.
So let me tell you my concern. So currently, if I'm representing somebody who's charged with some kind of sexual assault in nature, before they release the documents to me, we have to approach the judge. The state has to ask for a protective order. And then I, like you said, I can't give my clients copies of it. And trust me, my clients ask for copies all the time. I'm like, nah, I'm not about to lose my law license for you, right? But I'll explain stuff to them. The part that concerns me is the last part where you say, I've got to destroy the evidence, because we have to, as lawyers, keep evidence in our cases for 5 years. I mean, the bar requires that. And so if my client wants it, like they want to appeal, I have an obligation if they want to appeal. So cases don't necessarily end at disposition. And so I'll call TCDLA. I'm a member of TCDLA, but that's the part that has me concerned, because sometimes courts get it wrong.
Yes.
Right? Sometimes people plead guilty and they're actually innocent.
Yes.
And if you're destroying evidence, or we are destroying evidence, that just gives me pause. But I'll call TCDLA. I'm a member.
Yeah, and if we need to change that, I'm happy to change that. I completely understand what you're saying, and definitely when people are innocent, their right to appeal and all of those things, I don't want to interfere with that at all. So, yeah.
Okay.
But yeah, they had worked with us on the substitute language. So as from what I've been told, they have signed off on the substitute language. So, yeah. Okay.
And if there's the substitute, we have it. Okay. I'll look at it. But that's my only consternation.
Yes.
All right.
Understand completely.
Okay. And like I say, sometimes the system gets it wrong, at least initially.
Yes.
Okay. Thank you.
Okay, anything else, members? Okay, and we'll certainly allow you to close.
Okay, thank you.
And so the chair calls Ashley Brooks.
Good afternoon. My name is Ashley Brooks. I'm the Senior Policy Advisor with the Texas Association Against Sexual Assault, and I'm here in support of the bill on behalf of our membership of the Rape Crisis Centers in Texas, the survivors, advocates, and citizens who are working to eliminate sex crimes in Texas. I feel like Representative Hall summed up the bill fairly well, so I won't take up any more of the members' times, but if anyone has any questions, I'm happy to answer them. I wish Representative Jones was still here, because I did work closely with the defense attorneys on this substitute language, and I believe they even spoke in the Senate hearing that they are on board with the changes that were made in the bill. The bill has already been voted out of the Senate committee and is on the way to the Senate floor. And again, there were no objections in the Senate hearing on this bill.
Any questions for Ms. Brooks? Okay, thank you for being here. We have Bronwyn Blake. Thank you.
Thank you. My name is Bronwyn Blake. I'm the Chief Legal Officer at the Texas Advocacy Project. I'm here representing my agency and myself and testifying in support of the bill. Our agency, Texas Advocacy Project, provides free legal and social services to survivors of sexual assault and other forms of abuse across the state of Texas. I want to thank Representative Hull for filing this important piece of legislation that includes consent for all parties, flexibility for pseudonyms, and common sense safeguards protecting sensitive evidence. On behalf of the thousands of survivors that we serve every year at the Texas Advocacy Project, I urge you to support this bill. I want to thank you for your time and your leadership, and I'm here to answer any questions that you have.
Thank you, Ms. Blake. Any questions? We appreciate you being here. Thank you.
Thank you.
We have Sophia Strother Lewis. And if I mispronounce any names, I apologize. I'm reading off a very small print, so.
It's okay. It's Strother.
Strother. I should have said Strother.
It's a little East Coast. Thank you all so very much. Again, my name is Sophia Strother Lewis. I am testifying on behalf of myself as a survivor in favor of House Bill 1686 through Representative Hull. Thank you again for allowing me to speak. And as I stand before you, not just as a survivor of sexual assault, but as a re-survivor of a broken system under which I was known as cause number 2T0176K277, a system that failed to protect me, failed to inform me, and ultimately failed to see me. Please understand, when someone is raped, trafficked, or abused, they don't just endure a single trauma. Survivors are often forced to navigate up to 7 different systems: family and friends, society, faith, law enforcement, healthcare, prosecution, and the judicial system. Each system brings its own burdens, stereotypes, and wounds. For many of us, the systems meant to protect us become additional sources of pain. When I first reported my assault, I believed justice would bring closure. January 5th of 2021. I believed the courtroom would be a place of protection. I was wrong. Because I wasn't offered an advocate, I was unaware of the legal protections available to guard my privacy and security. During the prosecution phase, my entire identity was exposed. My name, address, social security number, and even my date of birth became accessible to the very man who violated me and everyone in the court to see, and is now a permanent part of the transcript and discovery evidence that anybody can request. That information was used to harass me, to track me, to intimidate me. I experienced fraud last year, identity theft, and unfortunately the unraveling of my multi-million-dollar business I had worked years to build. My entire life collapsed while trying to seek justice. After the trial, I had stalker to show up at my lot where I housed my Amazon vans. I received continual threats. Now my personal data is circulating on the dark web. Still no protection. No action from Amazon, no advocate assigned to help, no safety net, and no post after my trial. I was forced to shut down my company, the company I built from the ground up. An Amazon contract paying up to $2 million in annual payroll and employing hundreds here in the state of Texas. I'm now having to file for personal bankruptcy because my one decision to live, fight, to seek justice cost me everything. The rape alone didn't destroy me. Seeking justice did. So I ask again, in regards to holding up this bill, it is absolutely essential. I had an illegal immigrant convicted by the U.S. government for conspiracy and fraud and a multi-million-dollar Nigerian money laundering ring in Houston be convicted just 2 years later of raping me as well, and has now been on the run for 66 weeks. It has now been 1,551 days that I've been living in a nightmare, still bleeding emotionally, mentally, financially, and spiritually. When will the bleeding stop? Let it stop today. Let it stop with the surgical precision of your yes on this vote for 1686. Any questions?
Thank you very much. Any questions, members? We appreciate so much you being here.
Thank you.
Our next witness is Dr. Masters, again, Dr. Bertha Lavinia Masters. We have worn you out today, so we appreciate. Okay.
It's okay. I am Lavinia Masters again. I'm here to represent myself, and I support House Bill 1686. Representative Hull. I thank her for her work once again. And honestly, I can write a whole novel on what rape has done to me as an individual, how I feel my system has failed me in the past, and how we still struggle to make things right for survivors of sexual violence. But I'm not going to do that. What I'm going to do is first commend Sophia for her testimony and her courage, and just say that this bill is about empowering victims. This bill is about giving us, those victims that are fighting to be survivors, power to gain their lives back. Privacy is important to us. We have been exposed already to so much. The fear, like I spoke earlier, is there. There is so much pain and trauma associated with this, and then to have a systemic assault to happen to us by not protecting our privacy, not notifying us of when our perpetrators are out, and any other safeguards for us is devastating to a victim of sexual violence. And so I don't just stand for myself, I stand for many survivors. I get calls all the time as an advocate, and I don't charge anybody anything. I just want survivors to know that there is hope. I want survivors to continue to believe in our system because I believe in it. That's why I stand here. That's why I fight for survivors. That's why I use my voice. I want them to have the same courage to come forward and believe in you guys. You guys are going to make the right decisions when it comes to standing up and supporting survivors of sexual violence. We can't take back the things that happened to us, unfortunately, but we can move forward and try to with our healing processes, and we can do this together by upholding laws such as this that protect our privacy in all of this pain and trauma that we've endured. Thank you.
Thanks so much. Any questions? Okay, thank you very
Thank
much.
you.
Chair calls Tiffany Larson.
Hello again, I am Tiffany Larson. I represent the Brazos County District Attorney's Office as well as myself in support of House Bill 1686. I'll keep my comments brief, but I do just want to emphasize that the types of evidence that we gather and collect in an adult sexual assault is not dissimilar to what we collect in a child sexual abuse case. The nature of this evidence is graphic, but we haven't had any protections for this type of evidence when it comes to adult survivors. We've had wonderful protections in our Code of Criminal Procedure for many years now for child sexual abuse survivors. We're simply looking for parity here. Our amazing SANE nurses do a wonderful job being very thorough in their documentation when they go through a sexual assault examination, but you might imagine that the photos and as well as the specific information they're taking from the survivor about their last menstrual period, about whether or not a condom was used, whether or not they've had previous sexual partners, is very, very personal in nature. We are just seeking to prevent public dissemination of this type of material. Representative Jones isn't here anymore, but I do want to just comment that when it comes to destroying the records, obviously that would be any type of record that is in the possession of the defense. We will still, of course, have a copy of that record as the state, as well as likely law enforcement will retain a record. And so we're not concerned about this being lost forever, but we are trying to contain further dissemination of this type of evidence into the public realm by accident or just some type of kind of misuse of the information. And so that's what these protective orders would do. We don't have a law right now that actually provides for these types of protective orders. We've been doing this for many years as kind of a gentleman's agreement or a practice, but this would put it into law. Additionally, same with the public viewing of these proceedings. We're not trying to close the courts. Of course, anybody can always come down to the courthouse and watch a criminal proceeding. This is trying to keep people from just sitting at home streaming in the comfort of their own home, something that is so incredibly personal to our survivors and really needs to be viewed in person if it is important to the person viewing it. I'll take any questions.
Any questions, members, for Ms. Larson? Okay, thank you again for being
Thank
here.
you.
And we have Brenda Garrison.
Hello again. I'm Brenda Garrison, and I'm here today in support of House Bill 1686, and that's on behalf of Child Abuse and Forensic Services and myself.
Good job. I have
Got
to
that out of the way.
make it, we get all those covered, but thank you.
Okay, my testimony today is on the issue of live streaming. Like I said earlier, I have conducted over 4,700 sexual assault examinations on victims of sexual assault. When I opened my private office, my main goal, or one of my main goals, was to provide patients with the privacy, dignity, and confidentiality that they deserve. Live streaming via the internet of sexual assault cases undermines everything we stand for. It benefits no one except the people watching for entertainment. My county is one of those counties that live stream sexual assault cases. When it was brought to my attention, I really couldn't believe it. I had to watch it to actually realize it was happening. I couldn't believe it. But justice shouldn't be a spectacle for the public. Sexual assault trials involve deeply personal, graphic testimony. Live streaming turns justice into entertainment for casual viewers, not citizens genuinely seeking court access. Turning our courtrooms into a Judge Judy show makes a mockery of our courts. I ask you, should the dignity of victims and witnesses be sacrificed for public curiosity? What if the accused is found not guilty? You can never unhear what you've heard. So this would protect not only the victim but the accused from being live streamed across the internet. I think that also the harm that can come to not only the victims but the expert witnesses. We are up there, we're testifying, our names, our personal information is brought out. I think a good way to explain one of my concerns is in 2012 we had a shooting in the Jefferson County parking lot of the courthouse, and a lady was killed, and this was over a sexual assault case. And it being live streamed is just open for everyone. Over my 31 years of experience doing these exams, I've had multiple letters sent to me from individuals that were incarcerated. They didn't threaten me directly, but they let me know that they know who I am, where I am, and how to contact me. So it's a safety risk not only for the victims, but also for the expert witnesses that are coming in to testify on these cases. And in one national study, 33% of rape survivors said they had contemplated suicide. These are the numbers before live streaming. Those who had been raped were 13 times more likely than non-crime victims to have attempted suicide. Do we really want to expose these victims to further trauma?
Okay, thank you very much. Any questions, members, from Ms. Garrison? Thank you again for being here. We have one more witness, Alan Place.
Mr. Chairman, members, my name is Alan Place. I'm here on behalf of the Texas Criminal Defense Lawyers Association. First, I want to thank Chairman Hull in her office for working with us. I've signed up on the bill originally as filed. The bill was very broad. I think Representative Little made a comment earlier as on the original draft as it dealt with the Michael Morton Act, Chapter 3914. We were able to find common ground to where they could get where they wanted to go without addressing 3914, Michael Morton Act in any sort of way. These protective orders, as one of the witnesses has indicated, is something on certain types of material that we're used to. It has been more of a gentleman's agreement that was testified to, and this just stabilizes that in certain cases there is certain evidence that just needs to be handled in a certain way, and we have no issue with that. And so as written, I think it's fine. I don't think there's anything that would change the practice of the criminal defense bar in regards to the evidence they have. They're still under either protective order or they're under the requirements of the Michael Morton Act to continue to keep that evidence protected, basically. I think what she's referring to is, I believe in the substitute, there's a comment that the court has the ability to put under seal whatever evidence they may have at some point in time. I think that's in the substitute. So as written, we're certainly fine.
Great. Thank you, Mr. Place. Mr. Little has a question.
Sure.
I agree with you that the substitute is a vast improvement. I had one question that was kind of lingering in my mind, and it had to do with the protective order as it relates to the material that you don't want disclosed to the public. I know that this happens to me in civil cases. I assume it happens to criminal defense lawyers as well, but when you need an expert witness to review materials that are subject to a protective order, typically in a civil case, you'll have the expert consent to by exhibit, consent to the terms of the protective order so that the confidentiality of the material is preserved while the expert can still render a report and have his or her own copy so that the report can be generated. Do you have any concerns about that as the substitute is written?
My understanding is it's written that, as we know it today, will continue that way. It would be like in the Michael Morton Act, you can certainly share that type of information with an expert, okay? But again, there are still constraints on the defense attorney in regards to that information once once they have that, and that restraint by association goes to the expert.
Okay, thanks.
Anything else from Mr. Place? Okay. No other, okay, well, thank you for
Thank you,
being
Mr.
here.
Chair.
Mr. Place. Is there anyone else here to testify for, against, or on House Bill 1686? And Ms. Hall, you recognize you to close.
Thank you. And just to go over a couple things that some of the witnesses said on the destroying the evidence part, that is on page 3. It's the last section, C in section 4, right before section 5, where it talks about that. So two of the witnesses already covered part of that. The other part is it's things that are evident that's not offered or admitted as evidence. And so sometimes they're downloading the victim's entire phone and pictures that are not relevant and not admitted as evidence. And so it could be something like that to help protect their privacy there. So if there's no other questions, I will close.
Okay, any others? Okay, thank you very much for being here. Okay. Yeah, so if there's no objection from the committee, the substitute will be withdrawn, and it's withdrawn, and so House Bill 1686 will be left pending for now. Okay, Ms. Fairley, I've got Mr. Morales, and he needs to get back to some, so, and both, you have no witnesses, you've got 2, so we should get through those fairly quickly.
Thank you.
Okay. Ms. Morales, you ready?
Yes.
Okay.
Yes, Chairman.
So the chair lays out House Bill 3418 and recognizes Representative Morales.
Thank you, Chairman Smithy and members, and freshman Representative Caroline Fairley for giving me her spot. For the opportunity to present HB 3418, a bill designed to enhance public safety by preventing registered sex offenders from serving as ride-share drivers. This is akin to like Uber or Lyft, those type of ride-share companies, okay? Currently, federal law bars individuals on the National Sex Offender Registry from working as ride-share drivers. However, Texas law lacks a similar restriction for those on the state registry. Additionally, sex offenders who drive for ride-share companies are not required to disclose their status to passengers. This gap in the law puts Texans, especially vulnerable populations, at risk. Stakeholders have expressed deep concerns about the dangers of allowing sex offenders to operate in a role that provides private, often unsupervised access to passengers. HB 3418 closes this loophole by aligning Texas law with federal standards, ensuring that ride-share companies cannot employ registered sex offenders. This is a practical, common-sense measure that prioritizes public safety without imposing unnecessary burdens on businesses. Texans trust ride-share services to provide safe transportation. This bill reinforces that trust by ensuring passengers are not unknowingly placed in harm's way. I want to state also about 2 years ago, some of you may know, I'm an attorney, a litigator by trade down in South Texas. We were approached by a lady that was sexually assaulted up here in Austin. We were honored to have represented her against a ride-share driver that ultimately took advantage of her. She ended up being the one that was initially arrested, and while she was being processed in jail, a female officer paid the necessary attention to her and understood that she was not the actual aggressor, but she was the victim. They then initiated the sex rape kit and all of that, and then this was about 4 or 5 hours later, the police officers were smart enough to then visit the ride-share driver's home. Thank God he had not showered, so they were able to do the DNA test there, the rape test there, and ultimately we were able to prove that he had committed sexual acts. So they were both Travis, DA's office, moved forward with criminal charges. We were able to successfully represent her on the civil aspect of the claim. Obviously, as you can tell, it was something that left a lasting impression to her. Her words to us were, try to resolve this as soon as possible. I don't want to go through this and have an extensive litigation process. It is unfortunate that it happened to somebody that we know, that we're aware of, that we actually represented. This is happening in Texas. I was surprised also to know that there is a national registry and a state registry, and sometimes there is no synergy, and this would be able to address those issues. I think this is a good bill that addresses those issues, protects the public, and I'm happy to have received the support of the Uber folks also, who I think they generated a card in support, from what I understand, and in favor of this piece of legislation. With that, Chairman Smithy, thanks for the opportunity to present this bill. I believe this legislation will make a meaningful difference in protecting Texans, and I reserve my right to close if there are any witnesses.
Okay. We've actually already kind of addressed this topic a little bit earlier today. I know you probably weren't privy to all that, but
I do have notes with respect to
Yeah.
that, Chairman. I'd like to say the only difference is we support Chairman Howard's legislation. It seems that that's a more omnibus bill related to the Governor's Sexual Assault Survivors
right.
Task Force issues. But just in the sense, this is just basically carving out a number of her legislative acts. In the event that that bill doesn't pass, then we would have this that would actually protect the passengers and
Gotcha.
rideshare drivers.
Okay.
So it's much more limited in scope.
Great.
But happy to address any questions that you may
any
have.
questions? Okay. Thank you. We'll call our witnesses here, and I'll certainly permit you to close.
Thank you.
We have the chair calls Dr. C.J. Grisham. C.J. Grisham, I don't see, so we will note that I guess it's Mr. Grisham registered against the bill but did not testify. Brent McCain, don't see Mr. McCain, so we will also note that he registered against the bill but did not testify. Is there anyone else here to testify for, against, or on House Bill 3418? If not, Ms. Morales, you want to close?
I have not, my staff and I have not had the privilege of visiting with those two individuals that you mentioned. If they happen to come by the office, we'd certainly address whatever concerns they may have. And with that, I believe yes.
Ms. Bowers.
Thank you. Thank you, Ms. Morales. I do have a question, Representative. So the fiscal note suggests no significant fiscal implication to the state. So how do you envision law enforcement enforcing this law, particularly ensuring that rideshare companies are checking both federal and state registries?
My understanding is that we're leaving this to the actual rideshare companies to actually comply with this.
Okay.
I don't believe that the legislation has any penalty provisions. At this point, it was more so of an issue of obligating them.
Mm-hmm.
But if we continue to see that this issue persists, then obviously I think we may have to come with some penalty issues, unless I'm different in that. I misspoke in that. Is that correct?
I think
So
Mr. Go ahead.
Thank you, Mr. Chairman. Do you believe that additional resources might be needed to ensure compliance, or do you just expect that those rideshare companies are expected to bear the full responsibility entirely?
Well, I was very pleasantly surprised that Uber is already doing that at the national level and at the state level. So it seems that we have a number of rideshare, and now we also have those non driver vehicles also, which
the vehicles that don't have drivers. Yes,
Correct.
I'm losing the name of those. Autonomous. Thank you.
there you go. Thank you.
So
And so it seems that while there's a number of companies, and obviously everybody knows Lyft and Uber, it seems that one of the companies is already doing that, and I'm happy to report that that's what was reported to me. And it just seems that we need to get everybody else on board.
And so Uber has signed on. Lyft, you don't have yet. Have you consulted with any criminal justice reform advocates about potential unintended consequences on this legislation?
Those concerns were expressed to my staff with respect to the possibility of either these individuals wanting to be gainfully employed and having a life outside of whatever sentence that they may have performed and paid their dues. Unfortunately, I think that we need to weigh their rights with respect to the rights of all our public, and this is a reasonable measure in light. It does not drastically affect them, and because they are participating with both children passengers, teenagers, as well as adults, that I think that this legislative body should make sure that we are protecting the general public when it comes to those issues.
And I appreciate you bringing the legislation. I think that it's necessary, so thank you so very much.
I appreciate
And
your support.
I will be signing on to your bill.
Thank you.
Okay, anything else, members? If not, Mr. Little.
Thank you, Chairman Smith. Yeah, I was just going to say, I think your better enforcement mechanism is establishing the standard of care for these rideshare companies, that they have to search the registry. And now, I mean, if they don't do it, it truly is negligence per se. I mean, to the extent that someone gets harmed by a rideshare driver. So I think the self-enforcement by Uber and Lyft is probably even more effective than having the government take care of it.
And you know, both of our backgrounds are in the litigation aspect. I think you see it through those sets of eyes, and I think that it definitely sends a more definitive hammer in the litigation process if, you know, from a plaintiff standpoint, you're able to establish that negligence per se and be able to establish that here's a company that is really out there for the public, doing what's right, and, you know, complying with all of the measures even before, you know, these measures were put in place by the legislature versus, you know, X company who's not doing their due diligence. Thank you, Mr. Lip, and happy to hopefully count on your support as well.
Yes, sir. You have it.
Okay. Thank you, Mr. Morales. Any other questions, members? If not, if there's no objection, the chair will leave House Bill 3418 pending for now. Thank you.
Mr. Chairman, that is all I have before this committee. May I be excused?
You may be excused.
Thank you,
and
Mr.
we're
Chairman.
about
Have a good day.
finished.
Thank you.
Ms. Thompson, do you mind if I get Ms. Fairley's bill on? She has 0 witnesses, and I think it seems like a pretty simple bill. You got 4. Oh, either way, come on up, Ms. Fairley, if you will. The chair lays out House Bill 2355 and recognizes Ms. Fairley.
Thank you, Mr. Chairman. Smithy members, thanks for the opportunity to lay out committee substitute for House Bill 2355. Right now, the crime victims.
Hold on, let me get a substitute laid out. Mr. Moody will lay out the substitute to
Great.
2355. Any objection? Okay. Go ahead.
Okay, so right now, the crime victims compensation program, it helps victims and their families cover immediate cost following a crime. So this program, it's administered by the Attorney General's office. It offers a range of expenses, including medical bills, wages, counseling services. And so to determine the compensation amount, the Attorney General's office has special access to these key documents, such as law enforcement reports, witness statements, and criminal history records. These reports are still considered privileged based upon the original law enforcement agency whom the AG pulls records from, and are generally withheld from the public. However, once the Attorney General pulls the records, they become subject to the requirements under the Public Information Act for the Attorney General's office, which may not always be applied the same as the originating law enforcement agency because the office of the Attorney General is not investigating agency in this instance. This bill is very straightforward. It closes a loophole to ensure not only victims are better protected, but details surrounding ongoing investigations are kept confidential when it comes to these public information requests. I do have an expert witness here from the Attorney General's office presenting a committee substitute. No language is changed, simply provides just the official Ledge Council draft. With that, I reserve the right to close.
Well, we don't have an affirmation, so.
Oh, no.
But that's okay. I think if we need any information, we can get it from, we can talk to the AG's office on it.
Okay.
But anybody have any questions?
Yeah, I'd love to talk to the AG's office. They're very, very helpful. Just one quick note. The only thing in the sub is it's a council draft.
Yes.
This is the way they want to do it.
Yes. Yes, sir.
So the only note I have is I agree with everything that you're trying to do here. And I think you kind of laid it out, and I just want to make sure that this still comports with this, is if there's an agency that would be subject to the Public Information Act, and somehow the way the language is in the introduced, and I've got to compare it with the substitute, but because they've changed the way it's structured, is we're not trying to shield public disclosure if it would have been otherwise subject to public disclosure in the Public Information Act. So an agency can't just send something to the AG and be like, all right, now, even though we would be subject to public information, it's not because we've sent it this way. That's the only thing that I want to preclude, and it sounds like that's where you're trying
That
to
is
go
correct,
with.
yes.
Okay. All right.
But
that's
if you
all.
have further questions, we're happy to follow up and
No,
discuss
no,
it in detail.
that satisfies it. Thank you.
Members, I stand corrected. We do have a couple of affirmations from the Attorney General's office. Is there anyone still here from the AG's office? Oh, good. Why don't we get one of y'all to come up, if you would?
They checked that they weren't going to testify.
Yeah,
So
okay.
make sure it's one
So
of them.
come on up, and here's what we're going to do, is if you'll identify yourself and, that you're with the Attorney General's office, and then,
What's her name?
yeah, state your name if you would.
I'm Allison Garcia from the Office of Attorney General's Office, Crime Victim Services Division, on the bill.
Okay, and so what I'm going to ask you to do, if you will allow us or give us permission to change your affirmation that you did testify at our request. So I think there may be a couple of questions. Mr. Moody, did you?
I mean, you heard my statement. Like, I don't think Representative Fairley's not trying to create some pocket where we're going to create non-disclosure or essentially allow for a bar on public information where it would have been subject to that under 552 otherwise. I think the way that this is done as a council draft probably gets there. I just wanted your opinion on that.
That's correct. That this is not intended as a way to shield these generally. It's more to go to the originating agency because they'll best be able to weigh in on what
Correct.
exceptions to apply.
And they're going to have to go back to you anyway if they're going to say that they've gotten,
Correct.
they want to withhold it. So, okay, as long as that structure's not being tinkered with, that was my only concern.
That's
Okay,
correct.
anything else, members? Well, we appreciate you being here, and oh, I'm sorry, Ms. Jones has a question.
I'm sorry. The OAG's, you're neutral on this, but the OAG's position is what specifically?
Well, we're here today as a resource witness, so so we signed up on the bill.
Oh, the committee's, you know what, let me look at the committee sub. I'll go back to the bill's author.
Okay, all right.
Okay.
So anything else, members? If not, once again, we appreciate y'all being here and testifying.
Thank you.
Thank you very much. Anyone else here to testify for, against, or on House Bill 2355, this committee substitute? If not, Chair recognizes Representative Fairley to close.
One note, Representative Jones, I'm happy to connect with you
That's fine.
outside of this room to talk about the
That's
committee
fine.
sub. And I close.
Okay, any other questions, members? Okay, thank you for being here, and if there's no objection, the chair will withdraw the substitute to 2355 and leave 2355 pending for now. Thank you. So, Ms. Thompson, are you ready? Yes. Okay, the chair lays out House Bill 1953 and recognizes Ms. Thompson.
Mr. Chairman, members, thank you very much. Mr. Chairman, this bill grants victims the right to meaningful notice. Prosecutors will have to give survivors a 5-day notice or notice as soon as possible or practical about any court proceedings, as well as notices that a plea bargain hearing has been set so that the victim can prepare. It grants the victim the right to be informed that the prosecutor does not represent the victim. The bill grants the victim the right to have counsel communicate their rights, and it enforces a victim rights on an advocate. There's a substitute, Mr. Chairman, if you'd be kind enough to lay that out. And the
I'm sorry,
substitute.
there is a substitute, so Ms. Rodriguez-Ramos will lay out the substitute.
The substitute before you is identical to a Senate companion bill that has been the engrossed version of this bill, which addresses concerns from the prosecutors, and it clarifies Section 5 of the bill for child advocacy centers. Specifically, the substitute removes Section 1F2, Section 3, and Section 4 of the bill relating to penalties for victim rights violations, and it clarifies at Section 5B2 to ensure that we align with the best practice to ensure that we don't unintentionally capture child cases of sexual assaults or gravely alter the natural disclosure process of a child victim. Mr. Chairman and members, I have several witnesses. I'm available to answer your questions, and may I reserve, please, the right to close.
Absolutely.
Thank
And
you.
any questions for Ms. Thompson?
Thank you.
Thank you very much. The chair calls Samantha McCoy.
Good afternoon. Thank you. My name is Samantha McCoy. I'm testifying in favor of House Bill 1953, and I'm representing myself. I did speak with you all briefly this morning. So, as you know, I am a rape survivor. Among many of the injustices I faced, one of the most devastating was the absence of an advocate during the medical examination process. After being escorted into the emergency room by law enforcement, I was left in the dark, unaware of what to expect. As a terrified young adult, with no prior experience of even attending a doctor's appointment alone without my parents, I found myself stripped and prodded for evidence. As photographs were taken of my injuries, all I could think about was how desperately I wanted someone there to support me. The absence of an advocate continued during the investigative interviews with law enforcement. These interviews caused untold harm to me. I was disbelieved, mocked, and forced to repeat in excruciating detail the trauma of the assault over and over to multiple officers. Requests for breaks were denied, and at one point I pleaded for my mother's presence just for comfort. This too was denied. Words cannot fully capture how devastating this experience was. If an advocate had been present, they could have ensured I was treated with basic dignity, offering emotional support, facilitating breaks, providing access to resources, and ensuring fair treatment. Instead, I was left to navigate the system alone. Sadly, my story is not unique. Every day, survivors of sexual violence disengage from investigations because of these very gaps, leaving countless perpetrators held unaccountable. The national reporting rate for rape has plummeted from 40% to just 25% in the last few years, with survivors citing fear, mistrust in the system, and emotional distress as their primary reasons for disengaging. Among many other rights, House Bill 1953 ensures that no survivor ever feels abandoned by the very systems that were meant to protect them, by requiring the victim to be offered the opportunity to have an advocate with them during the medical and interview process. Cooperation from victims is essential to obtain justice and to hold perpetrators accountable. We owe it to those who courageously come forward to treat them with the care and respect that they so deserve. I urge you to favorably advance this bill. Thank you.
Thank you very much. Any questions, members? For Ms. McCoy, we appreciate you being here on this and the other bill as well. Ashley Brooks.
Good afternoon. I'm Ashley Brooks with the Texas Association Against Sexual Assault, and I'm here in favor of the bill. I know it's been a long day, and again, the Senate bill has already come over here, and there was no objections over there, no known concerns. I'm just happy to answer any questions if anyone has any.
Any questions, members, for Ms. Brooks? Okay, thank you again for being here. And we have Sophia Strother Lewis. Welcome back.
Thank you. Thank you again. My name is Sophia Strother Lewis. I am here on my behalf as a survivor in support of House Bill 1953. On January 1st, 2021, my world shattered. I was tortured, I was raped, I was kidnapped, held against my will by a man our system knew was a threat, a man who should have never had access to me. His name is Augustine Dafi-Akulo. He's an illegal immigrant from Nigeria who had already been convicted of a federal crime in 2018 as a part of a 7-person money laundering scheme targeting U.S. victims. He was sentenced to 97 months in federal prison in order to pay nearly $850,000 in restitution, but somehow, just 1 year later, he was released. And in 2021, he didn't just steal money, he stole my safety, he stole my dignity, he stole my peace. On November 16, 2023, he was finally finally convicted of raping me in Williamson County. But for the last 66 weeks, he's been on the run. He cut off his ICE monitor and disappeared before sentencing. That's 66 weeks of living in constant fear. Every time I enter a room or open a door, fearing he may be there. What's worse is when I found the courage to pursue the justice, it's the system that abandoned me in the interim. I was never offered a victim advocate by local law enforcement in Georgetown. I was never given information about local resources. I was actually told by the assistant district attorney, who's no longer in Williamson County, thank God, I didn't need an attorney. I was told that the state was my attorney and would protect me, but they were inaccurate in that information because I do deserve to have an advocate and my own lawyer. I was left to navigate this nightmare alone. I was misled about his custody status. I wasn't notified when he was released from federal custody for violating his parole with my case. And then I was told I had to collect my own evidence to fight for his bond revocation. After he tried to bribe me with a car, after he harassed me and blew up 3 of my vans on Howard Lane in Austin. Again, after being threatened, harassed, and bribed, messaged for money, all because I was not afforded to know what the rights I had for me. This isn't just about me. It's about every survivor whose suffering is worsened by a system that prioritizes bureaucracy over basic human dignity. This bill matters. It's not just about asking for anything radical. It's really basic minimum. The right to be notified at least 5 days before a plea deal, before they're scheduled, rescheduled, or canceled, which I had to beg for time and time again because Texas Vine is not enough. The right to have a dedicated victim advocate to stand with us and to be educated that the prosecution's advocate is actually not there to be with us through the process or post-process. They're primarily there to convey basic information if you have questions and only there during your trial. The right to know that the prosecutor is not our attorney and that we are to be informed that that fact from the start. This bill is not just words. It's a lifeline, it's justice, it's dignity, it's humanity. I have already lost so much. Millions of dollars, literally. My business, my sense of safety. Don't let another survivor come before you 2 years from now telling a story like mine. Let mine be the last. Please vote yes for HB 1953.
Well, thank you for sharing your experience with us. It's very helpful.
Thank you.
I think in this bill. Any questions, members? Ms. Jones has a question.
I actually don't have a question. I just want to say you were powerful, right? In a very limited amount of time, you are powerful. So that's all. And I'm sorry for what you went through.
Thank you so very much.
I think we all are, and we do appreciate your testimony a lot.
Thank
you. Did a good job.
Thank you.
Thank you. We have Bertha Lavinia Masters again.
I am Lavinia Masters. I am representing myself, and I'm in support of House Bill 1953. First, I want to start by saying, because this is my last time speaking today, I am exhausted physically, mentally, emotionally, and I want to say I appreciate each and every one of you for listening to these survivor stories, as I know they can sometimes be taxing on you, and I pray that you all practice self-care yourselves after listening to us. My story, many of you already know my story. I was violated at 13. Someone broke into my home, raped me violently at knife point. Imagine someone doing that to your daughter, your granddaughter, your nieces, your nephews, coming in their home and ripping their flesh apart, and you're upstairs sleeping and you don't know about it until the devastation has happened. I just wanted justice, I wanted fairness, and I wanted equal treatment as this law is stating, but I didn't get that. I didn't get any kind of notifications. I didn't get anything. Fast forward, we're fighting for victims of sexual violence still today in 2025, and my rape was in 1985. And sometimes I get a little frustrated because it's like we should be beyond this in this fight. We should already know the devastation of what a rape victim goes through and the things that can have a domino effect after that. I don't want pity from anybody. I don't want you to feel sorry for me. I don't want you to say, woe is me. I want you to say that we're going to fight for you. We're going to fight for ourselves. We're going to fight for our families and generations to come, and we're going to enforce these rights. We enforce traffic light tickets. We enforce, I think we were enforcing no drinking even in this room, but we won't enforce the rights for victims and make sure the crime victim rights are enforced properly so we can be notified, bless you, we can be notified or have an advocate or right to counsel. This is only fair for a victim of sexual violence. It's not about me and my face. It's about the millions of victims of sexual violence. It's about those who have yet to come forward. It's about those that watch us and in which they had the courage to do the things that we do. We speak for them. We speak for ourselves. We speak for you. We speak for your families. And I just want you to know that we support House Bill 1953. We pray that you support it. You understand where we're coming. We're not just coming saying, woe is me. We already know that we matter. We figured that out. We matter, but we need you to understand that we also matter. We want you to say, I see you, I hear you, and I believe in you, and I will support you with these laws. Thank you. Any questions?
And thank you again. And so for you and the other survivors that came, I think I speak for the men on this committee and tell you, there's no possible way we can truly understand what
Yes.
you've been through
Yes.
or what it's like to be sitting out there and coming in and testifying.
Yes,
But
yes.
it is very helpful to us in trying
Yes,
to make these laws work.
Yes.
So once again, we've said this before, but we all appreciate you being
appreciate
here.
you. Listen, thank you.
And I know hopefully a lot of people in the future will appreciate it by preventing some of you other people going through what you all have.
Yes.
And
Yes.
let me see if there's any questions. Ms. Jones?
So when the advocates come, I guess to provide support for you guys, so what do you want for them to do? What kind of stuff do you want the advocates to do?
I didn't have it. So what we're doing now is advocates come giving us the resources, showing us just support. A lot of times we're not comfortable with just police officers going into the hospitals, not knowing what's going to happen next, but someone we feel is trained who is basically, I want to say on my level of understanding, because me as an advocate, the training I've been through, many advocates have been victims of a violent crime, and so they can identify with me, but someone who can just make sure I have the proper, they go through the proper protocol themselves, and I have the proper resources and what happens next, and just keeping me informed, because when I was raped, everything was chaos, even for my mom. And she had, not knowing at that time, she had also been a victim of a violent rape at a young age. So it just cast my whole family into this state of chaos, and we didn't know where to go. We didn't know where to begin. But having an advocate there, someone who's trained, who knows what's next, what happens next, who follows up. Because I understand officers, you have more cases to do. I understand judges have to do, you have your, keep things rolling, but that advocate is there for me as a victim and make sure that I can know the next step, what happens next. I have the counsel, you have rights to this, you have rights to that, and that needs to be enforced in that aspect.
So these are some of the things, when I get hired to help walk a victim through the system, most of the times they've never been a victim. Right. So they've called me like I'm supposed to check, like especially if the person is locked up.
Yes.
Like they're calling me constantly to let them know if the person is getting out, if the person's getting out, if the person's getting out.
Yes.
I've seen that there's a lag in I think it's called Vine, where
Yes.
it's supposed to
She mentioned
notify
Vine.
the victims. Vine doesn't always work.
No.
And so I also know that, like, for example, my clients have asked me, like, what's going to happen in court? Like, what is this for? Like, how come the bond is so low? And so I don't know who's going to develop. I guess I can ask the bill's author, just like teaching, because I would have to go into like the Harris County District Clerk's website or whatever county I'm in, trying to help people because they just want to know.
No. And
They just don't know.
Yeah, those are some of the things, my understanding that an advocate would provide or do the research for the victim because, like I said, you have as a lawyer, the work you have to do, but the advocate has the work in being right there for that survivor of sexual violence, that support system, basically.
And then I like refer them to like a place in Harris County called AVDA, Aid to Victims of Domestic Abuse, where they provide group counseling, individual counseling.
Yes.
They actually do divorces if you're married to your abuser.
Yes.
They do protective orders if you need to get away from your abuser. They have partnerships with law enforcement to get you documents, like maybe you had to flee your house and your kids' documents are left at the house to be able to re-enroll the kids in school. So those are the kind of things I would imagine an advocate could help you with. Okay.
Yes.
And I'll work
and
with
help build the trust back with that victim as well, knowing I have that individual support system for me throughout the process. Yes, ma'am.
Yes, ma'am. Thank you.
Thank you.
Okay, any other questions? We really appreciate you being here. Is there anyone else here to testify for or against or on House Bill 1953? If not, Ms. Thompson to close.
Mr. Chairman and committee, I close.
Okay. Any questions for Ms. Thompson?
Yes.
Mr. Little?
Just very briefly, Dean Thompson, I just had, there was one sentence in the bill that I had a question about, and this might, I just asked for help from the other attorneys that are here on our committee. On page 8.
Is that the bill substitute that you're
Yeah,
talking?
I'm reading for the substitute.
Okay.
Yes, Dean Thompson. There's a section, section 5, but it's your new B-2, and it describes that a victim has the right to have an attorney present during an investigative interview with the victim, and you talked about that in your opening. My only concern was this second sentence says the attorney may not unreasonably delay or otherwise impede the interview process. And as I was reading that last night, I was thinking to myself, oftentimes there can be good reasons to delay or impede an interview. If you're representing a client, it could be that they're getting ready to confess to a crime and may not be aware of it. Or I can give you a situation from my own life where I was representing a victim of abuse who was being interviewed. And my concern was if he was sexually abused by another classmate, my concern was if he was interviewed more than once, someone's going to use the inconsistencies in these interviews against him. And so my concern really is that second sentence, because oftentimes it is the obligation or duty of an attorney to get in there and say, stop, we're messing something up, and impede or delay that process. So I don't know if you have any thoughts about that or if any other committee
No, but
members
I
do.
work, this has been a process we've been working with the prosecutors on, and we can get them to further clarify it because we don't want to put anybody in an untenable position.
Certainly not, and the substitute was a great improvement, so I appreciate your doing that. Thank you.
Thank you.
Okay, anything else? Thank you, Ms. Thompson.
However,
What's,
if you feel generous,
well, I am generous, but we've got several members that will want to vote on this. Oh, tell us again the status of this, the companion in the Senate.
I don't know the status of the
Okay.
companion, but I think it may be, the Senate bill has been engrossed, and it may be over the House, and then we'll substitute the Senate bill for the House bill.
Okay, all right. Ms. Jones has.
So, Dean Thompson, is this attorney on what Rep. Little asked? Is this attorney like, if somebody hires me, right, to represent them, to get them through this system, I actually think that this would be an interference with the attorney-client privilege. I mean, unless I'm reading it wrong.
We're not hiring anybody to interfere with the process. They are being to represent, help this person through this ordeal that they have encountered.
Which is good, and my concern that I was trying to share with the committee, and I think Representative Jones has seized on it, is I want you to imagine a situation where you have a victim of sexual assault, and they were sexually assaulted in the middle of a gigantic drug deal. And they have to lay this story out as part of their forensic interview, but they may be confessing to another crime as they're laying it out. And so my concern was preventing an attorney from delaying or impeding an interview may actually interfere with that attorney's duties. So that second sentence was given me a little bit of heartburn, and maybe I don't know enough about it, but I was curious about that.
Rep. Thompson. So I wasn't even talking about like where maybe somebody committed a crime. Here's what I know. When I've ever dealt like on the defense side, I always tell my clients to speak to me first, because if you've been traumatized as a rape victim, right? So you may not be thinking
Clearly.
straight, right? And I'd like the opportunity to speak to my client first so that I can make sure that they're accurate, because the DA has to put down everything they say, right? And so they may honestly make a mistake and they're not accurate. And a good defense lawyer is literally gonna seize on that and say, well, you said this the first time, you said this the second time, they're not the same thing, so which one is true or whatever. And so there may be a need for you to help to protect your client, just to get the story straight, because it sounds like you're trying to make up a story. But most people aren't paying attention to what they're doing, and probably if you're a victim of a rape, you may not be aware of stuff. Like you hadn't had a time to sit down and process it. So you want to get an advocate for the person to tell me what happened. And then you can work that out so that when they do go speak to an interviewer, then they're accurate, because we need for the stories to be consistent all the time. And then another situation might be that the person, if they've hired you as a lawyer, we have canons, right? There are times when I will give my client advice and my client doesn't want to use my advice, right? Or I may see where my client is going to do something to hurt themselves and they may not want to. I just think that telling a lawyer that they can't stop an interview with the state interferes with the confidential and fiduciary relationship a lawyer has to their client. But I'll come to your office,
Okay.
and so we can just
And
try
I'll
to
talk
fix
with
it.
I'll talk with the prosecutor's office, because that's what we've been working with, to make sure that we don't have a lawyer who's interfering with their job and trying to do what they need to do, but also not interfering with the person who is also the representing the victim as well.
Right, but so people have a Fifth Amendment right,
Sure.
like to remain silent. They don't have to talk to the police. And I guess my concern is I can see if there's going to be an enforcement. If I'm trying to help my client and the prosecutor's mad because because they perceive what I'm doing and representing my client as an interference, next thing you know, I may get charged. I mean, I'm not in trouble for trying to advise my client of something. I mean, I've had cases where I said, may we stop this interview? Let me speak to you. And where I go and I take my client out and say, hey, are you certain this is what happened? Because this is different. And I can just see non-nefarious explanations for why a lawyer might want to intervene when they see where their client is going. And I don't want, because then you're going to have lawyers, if I literally don't have the right to try to do what I believe to be, as a lawyer, in the best interest of my client, I think it'll discourage lawyers for getting involved if I have to let you talk to my client because law enforcement wants to talk to my client.
I think the big thrust of this was to make sure that if the victim wanted a lawyer, their own lawyer,
Yeah.
that they could.
I think
They could get their lawyer, and if that lawyer was advocating in some capacity, but not to do anything to put themselves in jeopardy or to jeopardize the case of the prosecutor. That's the big deal, because I think the shock seemed to have arisen that the victim may think that the prosecutor, since they are the prosecutor, is their lawyer, and the lawyer also, represents the state. And I think that we're trying to make a division and let them know that there are two different clients here.
The attorney that you're talking about in that section, is that the state's lawyer?
No, that's the person that you hired, their own lawyer.
But it's the victim. victim that's in the interview, not the defendant. I think you're referring to your client being the defendant.
No, because I literally get hired to represent people who are victims of crimes, and they don't think the system is working for them for whatever reason, right? They just don't trust it. No one's getting back to them. So the only way they can get information about their case is from me. And they want for me to help prepare them for this system. And there just can be times when you see this might hurt my client's ability to have the prosecution prove their case beyond a reasonable doubt. I want to be able to stop them so that there'll be a strong, prosecutorial case, and my client literally could be hurting themselves. They really could. And I have had to do that on occasion.
Yeah, we don't want to, interfere with the lawyer and the client in that situation. Anything else, members? Okay, if there's no, you have anything else, Ms. Thompson?
No, sir.
Well, we'll get to work on it.
Thank you very much.
If there's no objection, though, we'll withdraw the substitute. No objection, so the substitute's withdrawn, and we will leave House Bill 1953 pending for
Yeah,
now.
because the Senate bill, I think, is already over.
Okay?
Thank you.
Yes, we just checked, and it has been, it's sent over to the House, but has not been referred yet, so we'll check on the status of that.
Thank you.
Okay, members, anything else? That brings us to the end of our bills on the schedule. Don't forget, we have a subcommittee meeting on Thursday. Is your subcommittee meeting this week, David? Okay,
8 a.m. and then 8 a.m. for juvenile justice on Thursday, and then the second subcommittee is after the floor.
okay, 8 a.m. And then on the, so if there's no other business, the committee will stand adjourned pending call of the chair.